Respectfully, Lord, my name is I rest on the earlier appearances for the prosecution. Thank you, my Lord.
Thank you. I try to appeal to the defendant to compose himself and in his usual rude manner he refused, and I think we have to go on. Let me hear from counsel to the prosecution force.
Please, Your Lordship, there's no doubt that this court is a court of law, court of justice, and a superior court of record where conduct of parties, their counsel, are guided and regulated by the Administration of Criminal Justice Act. What we have just witnessed by the defendant is a misconduct which justifies the provision and invocation of Section 266 of the Abuja.
266?
Yes, my Lord. If you permit me, sir, I read.
You may read, sir.
A defendant shall, subject to the provisions of Section 135 of this Act, be present in court during the whole of his trial, unless he misconduct himself in such a manner as to render his continuing presence impracticable or undesirable, or at the hearing of the interlocutor. So it's 266(1)(a). So I'll be urging Your Lordship to invoke that section to remove the defendant from this further proceedings. And I thank Your Lordship, sir. It is in the interest of justice that the court should function according to the law. It's not to be at the behest of parties.
Yes.
Thank you, my Lord.
Well, I must say this. The presence of a defendant throughout the trial, it is a constitutional right, and it's contained in Section 36 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Also, this temple of justice is temple of God, because God himself established this temple for justice. So the sanctity of this temple must always be maintained. The unruly behavior of the defendant is not a new one, but he has gotten to a level that these courts have to make progress. We've seen instances where the defendant will beat his counsel to keep quiet and not talk where he's talking. We've seen instances where he will move against security officers. Let's come back to this morning. He acted unruly. I appealed to him severally. I asked him to be excused. I asked him to excuse us. The security officers moved to him. They begged him through severally. In his usual manner, he refused to comport himself. Institutions must be respected. We must act according to rules and laws. nobody is above the law. That is the essence of having court of law. If we allow anybody to act anyway, the sanctity of this temple will not be there. As a judicial officer, I'm bound to protect the sanctity of this temple of justice. Like I said earlier, the right to be present throughout the trial is a constitutional right. Even fundamental rights. But fundamental right is not absolute. It's opportunity to use that right that you have. Please don't open that door again, please. Once you have been given the opportunity and you fail to use that opportunity, such person cannot claim a breach of that right. This morning, the defendant was given that opportunity. He has raised the issue, he's raising severally. He has conducted himself in this manner severally. And I think this is the time to put a stop to it. It is right law that if a defendant misbehaves or acts unruly in the courtroom, his trial can be done in his absence. As stated by the defendant this morning, he said he has put in his defense. He is not calling any witness, that is only written address. And I will get to the issue of written address in the judgments. We are not taking evidence this morning. Is to take judgment and sentence if possible. It is based on that I hereby make an order that because of the unruly behavior of defendants, his aggressiveness and violent nature, I hereby made an order that the judgment and other proceedings proceed in his absence. I take my judgments. The defendant was arraigned before this court on 7-count charge, which reads thus. Count 1. That you, Nnamdi Kanu, male, adult, of Afaranuku Ibeku in Umuahia North Local Government area of Abia State, sometimes in 2021, being a member and the leader of Indigenous People of Biafra, IPOP, a proscribed organization, did commit an act in furtherance of acts of terrorism against the Federal Republic of Nigeria and the people of Nigeria by making a broadcast received and heard in Nigeria within the jurisdiction of this court with intent to intimidate the population, and you threatened that people will die, the whole world will stand still, and you thereby committed an offense punishable under Section 1, Sub 2B of the Terrorism Prevention Amendment Act 2013. Count 2. That you, Nnamdi Kanu, male, adult of Afaranuku Ibeku in Umuahia North Local Government area of Abia State, sometimes in 2021, did commit an act in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, made a broadcast received and heard in Nigeria within the jurisdiction of this honorable court with intent to intimidate the population, you issue a deadly threat that anyone who flouted your seat at home order shall write his or her will. As a result, banks, schools, markets, shopping malls, fuel stations, domicile in the eastern states of Nigeria were not open for businesses. Citizen and vehicular movements in the eastern states of Nigeria were grounded within the jurisdiction of this honorable court, and you thereby committed an offense punishable under Section 1, Sub 2B of the Terrorism Prevention Amendment Act 2013. Count 3, that you, Nnamdi Kanu, male adult of Afaraku Ibeku, Umuahia North Local Government of Abia State, on dates between 2018 and 2021 within the jurisdiction of this honorable court, profess yourself to be a member and leader of indigenous people of Biafra, IPOB, a proscribed organization in Nigeria, and that you thereby committed an offense contrary to and punishable under Section 16 of the Terrorism Prevention Amendment Act 2013. Count 4, that you, Nnamdi Kanu, male adult of Afara Nuku Ibeku, Umuahia North Local Government Area of Abia State, on date between 2018 and 2021, made a broadcast received and heard in Nigeria within the jurisdiction of this court in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, in which you incite members of the public in Nigeria to hunt and kill Nigeria security personnel, and that you thereby committed an offense punishable under Section 12H of the Terrorism Prevention Amendment Act 2013. Count 5. That you, Nnamdi Kanu, male adults of Afara Nuku Ibeku, Umuahia North Local Government Area of Abia State, on date between 2018 and 2021, made a broadcast received and heard in Nigeria within the jurisdiction of this court in furtherance of an act of terrorism against the Federal Republic of Nigeria and people of Nigeria, in which you incite members of the public in Nigeria to hunt and kill families of Nigeria security personnel, and that you thereby committed an offense punishable under Section 12H of the Terrorism Prevention Act 2013. Count 6. That you, Nnamdi Kanu, male adult of Afara Nuku Ibeku in Umuahia North Local Government Area of Abia State, date between 2018 and 2021, made a broadcast received and heard in Nigeria within the jurisdiction of this court in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, in which you directed members of the indigenous people of Biafra, IPOB, a proscribed organization, to manufacture bombs, and you thereby committed an offense punishable under Section 12F of the Terrorism Prevention Amendment Act 2013. Count 7. That you, Nnamdi Kanu, male adult of Afara Nuku Ibeku in Umuahia North Local Government Area of Abia State, on date between the month of March and April 2015, imported into Nigeria and kept in Ubuluzo in Ihiala Local Government Area of Anambra State. Within the jurisdiction of this court, a radio transmitter known as Tram 50L concealed in a container of used household items, which you declare as used household item, and you thereby committed an offense contrary to Section 47(2)(a) of the Criminal Code, Cap C45, Laws of the Federation of Nigeria, 2004. In discharging its burden of proof, the prosecution called 5 witnesses as follows. 1. Mr. AAA as PW1, Mr. BBB as PW2, Mr. C66 as PW3, Mr. DDD as PW4, Mr. EEE as PW5. The prosecution also tendered the following, which were admitted in evidence by these courts. 1. A document titled Items Recovered from Nnamdi Kanu of Radio Biafra at Golden Oakley Hotel located at number 42/44 Airport Road, Lagos on the 15th day of October 2015 was admitted and marked as Exhibits PWA. 2. 2 discs titled Interview with Nnamdi Kanu and a certificate of compliance filed on the 28th day of April 2025 were admitted and marked as Exhibits PWB and PWB2 respectively. 3. The statement of the defendants dated 15th day of October 2015 was admitted and marked as Exhibit PWC. 4. A process titled A List of Items of Nnamdi Kanu filed on the 19th day of March 2024 was admitted and marked as Exhibit PWD. 5. 4 bags as identified by PW1, Mr. AAA, were admitted and marked as Exhibits E-Bag A to E-Bag D respectively. 6. Items in Exhibit E-Bag A as identified by PWA were admitted and marked as Exhibit E-Bag A1 to E-Bag A13 respectively. 7. Items from Exhibit E-Bag B were admitted and marked as E-Bag B1 to E-Bag B32 respectively. 8. 10 items from Exhibit E-Bag C, Exhibit E-Bag C1 to Exhibit E-Bag C10 respectively. 9. Contents of Exhibit E-Bag D were admitted and marked as Exhibit E-Bag D1 to Exhibit E-Bag D17 respectively. 10. A letter dated 10th day of June 2021 from the Attorney General of the Federation and Minister for Justice addressed to the Director General, Department of State Service was admitted and same was marked as Exhibit PWF. 11. The statement of the defendant Nnamdi Kanu dated 17th day of July 2021 was admitted as Exhibit PWG. 12. A device to it, flash drive, black and red in color, and a certificate of compliance were admitted and marked as Exhibit PWH and PWH1 respectively. 13. A disc in respect to the statement of the defendant taken on the 17th July 2021 and certificate of compliance thereto were admitted and marked as Exhibit PW1 and PWI and PWI1 respectively. 14. Federal Republic of Nigeria Official Gazette number 99 in volume 104, dated 20th day of September 2017, titled Terrorism Prevention Order 2017, was admitted and marked as Exhibit PWJ. A document to its medical report titled Relates Ahmed Gulak, hospital number 013931, dated 18th July 2021, was admitted and marked as Exhibit PWK. 16. A certified true copy of the judgment in HIN/FR/2021 between Nnamdi Kanu versus Federal Republic of Nigeria and 7 others, delivered on the 19th day of January 2022, was admitted and marked as Exhibit PWL. 17. A certified true copy of judgment in FAC/UM/CS/30/2022, delivered on 26 October 2022 between Nnamdi Kanu versus Federal Republic of Nigeria and 2 others, was admitted and marked as Exhibit PWM. 18. A certified true copy of the judgment in suit number E/2023 between Mazi Nnamdi Kanu applying for himself and on behalf of members of indigenous people of Biafra IPOB versus Federal Republic of Nigeria and 4 others, delivered on the 26th day of October 2023, was admitted and marked as Exhibit PWN. 19. A document titled Lagos State Judicial Panel of Inquiries on Restitution for Victims of SARS-related abuses and other matters, was admitted and marked as Exhibit PWO. 20. A faster flash drive with certificates of compliance were admitted and marked as Exhibit PWP and PWP1 respectively. 21. A disc titled Interview with Sahara Reporter with certificate of compliance was admitted and marked as Exhibit PWS. 22. The search warrant dated 28th day of October 2015 with search reports was admitted and marked as Exhibit PWT. 23. A disc mask radio transmitter extra with certificate of compliance was admitted and marked as Exhibit PWU. 24. The statement of Benjamin Madubugu dated the 3rd day of November 2015 was admitted and marked as Exhibit PWV. 25. A SanDisk flash drive with its attachments and also with certificate of compliance was admitted and marked as Exhibit PWW. 26. Online printout of Vanguard newspaper and certificate of compliance was admitted and marked as Exhibit PWS. 27. A container containing a transmitter was admitted and marked as Exhibit PWY. 29. A certified true copy of report on request for professional assessment of radio transmitter dated 25th day of November 2015 was admitted and marked as Exhibit PWA2. 30. Certified true copy of Vanguard newspaper of 3rd day of July 2021 from National Library was admitted and marked as Exhibit PWB2. 31. The payment receipt with revenue collection receipt from National Library of Nigeria receipt number 19128 of 7th June 2025 was admitted and marked as Exhibit PWC2. 32. The report of assessment of the damage as a result of NSAS was admitted and marked as Exhibit PWD2. 33. Death reports and certificates of security officers was admitted and marked Exhibit PWD2A. 34. Certificate of compliance was admitted as Exhibit PWD2B. PW1. The evidence of the witnesses. Mr. A.A.H. is an officer of the Department of State Service. His schedule of duties includes arrest, investigation, and taking of statements of suspects. According to him, the defendant is the leader of the indigenous people of Biafra group. He stated that his first contact with the defendant was on the 14th day of October 2015, when he was detailed by his commander in the Lagos office to go to Essential Airport Hotel to arrest the defendant. PW1 stated that he went with some other officers, with one of them named Bolaji Adeyemo. On arrival at the hotel, they introduced themselves and informed the hotel workers that they were there to arrest the defendants. PW1 even showed the receptionist the photograph of the defendants, but he was told that the defendant was not in the hotel. He then asked for the guest manifest, but the name of the defendant was not on the manifest. So PW1 reverted to his commander, who then ordered that they conduct room-to-room search. In the process, they enlisted the cooperation of the manager of the hotel, who availed them of the master key of the rooms. Shortly after, Bolaji called PW1, who was downstairs, with his director, informing him that he had found the defendant in room 303. On getting to the room, PW1 stated that he met a young lady who was later identified as Miriam Ibezimako. He introduced himself to the defendant and informed them of the purpose of their visits. Thereafter, they proceeded to arrest the defendants, who initially resisted arrest. PW1 further stated that during the encounter, Bolaji intervened to calm the situation after the defendant had booted him, whereupon the defendant eventually agreed to follow them to the station. PW1 stated that the room looked like a broadcasting studio due to the broadcasting items mounted on the table, such as microphone, a tripod and airpod, transmitter, mixer, and cords. PW1 said they located the defendant at about 23 hours of the day. When they arrested him, they also arrested him with some of his baggage, which was listed in this sheet of papers, which the defendant signed. He said the items recovered were about 70, and it took some time for him to complete the inventory. PW1 stated further that on the following day at about 9 a.m., he was instructed to take the statement of the defendant. So he took him to the interview room and recorded the statements from him, which was captured on video. PW1 stated that at the time he took the statement of the defendant, the allegation against him was that he was the founder and leader of an organization known as the Indigenous People of Biafra, IPOB, through which he allegedly agitated for the violent secession of Nigeria's southern eastern states, South states, and as well as 2 states from the north central region, namely Benue and Kogi. Also, that he founded Radio Biafra, through which he broadcast his intentions, inciting the general public, particularly his followers and those who are sympathetic to his cause, to violence to achieve the secession he was agitating for. PW1 then stated that he issued the defendant with this service statement form after administering the cautionary word onto the defendant, and then he proceeded to write down his statement. The defendant signed the statement, and same was countersigned by him, PW1. PW1 stated further that the international passport of the defendant was recovered and brought to them the following day by the manager of the hotel, who found the passport on the bedside locker. Also, that the defendant used the name of Owenekeyi Ezebigo to book the hotel accommodation, and that was the name in the manifest. PW1 stated that during the interview of the defendant, he admitted to the allegation against him that he is indeed the founder and leader of Indigenous People of Biafra Group, and that he operated Radio Biafra, which is not registered by the Nigerian Broadcasting Commission or any other government agency. In addition, the radio station broadcasts information across Nigeria and the world at large. Under cross-examination, PW1 stated that he was one of the officers who interviewed the defendant and that during the interview, the defendant's lawyer was not present. PW1 said he took the statements of only the defendant and that the items recovered from the defendant did not look offensive. Also, that they did not analyze the phone of the defendant as they thought it was immaterial at that time. He said he did not personally arrest and investigate any person who may have committed any crime on the instigation of the defendant. Furthermore, that he did not investigate the lady arrested with the defendant to see if she was aiding the defendant in terrorism activities. PW1 denied knowing if the defendant's name named any other person as a co-conspirator or if any other person is standing trial on a related charge. PW1 said from his knowledge, the defendant had the support of persons like Simon Ekpa in his agitation for secession. He said the defendant incited others to destroy public properties. PW1 stated that even though there have been killings in other states, such as Kaduna, Zamfara, as far as he could tell, those killings were not product of agitations for separation. He said he knows that IPOB was prescribed in 2017, but he does not have other details of the matter. PW1 stated that there are people who carried out the order of defendants, including sit-at-home order, in which people have been killed for disobeying the directive. He stated that he is not aware that a charge against the defendant for inciting person to kill military officer was struck out by the court. Under re-examination, PW1 stated that the agitation of the defendant in this case is for a call for separation from the country for the southeastern, south-south, and some north-central states. PW1, Mr. BBB, is an officer of the Department of State Service. He stated that the defendant is a member and leader of prescribed terrorist group called IPOB, which means the Indigenous People of Biafra. PW2 also stated that he was assigned to take the statement of the defendant on the 17th day of July 2021, and that the purpose for the statement was for him to answer to the allegation contained in the letter sent to them by the Honorable Attorney General of the Federation. PW2 stated that the defendant is also the founder of Eastern Security Network, which is the armed wing of IPOB, and that he also established and operates Radio Biafra illegally, which was not registered with the Nigerian Broadcasting Commission, that the defendant told him all this during their interactions. PW2 further stated that during this interview, he was with his director and 4 other officers, as well as the defendant and 2 of his lawyers, namely Mr. Aloy Ejimako and Abila Tokchak. That the defendant admitted that he made broadcasts inciting people to burn, kill, and collect weapons from police officers wherever they see them. That the defendant also made written statements on the same day. He said the defendant admitted founding the Eastern Security Network, and that he admitted making broadcasts where he ordered his followers to ensure that whoever flouts the sit-at-home order be attacked, and they led to the death of many people, including destruction of properties. PW2 further stated that one of the unfortunate persons who lost his life includes Ahmed Gulak, a former senior special assistant to the President Goodluck Jonathan, who died on 30th May 2021. and also that the defendant made broadcast on the 20th day of October 2020 during the NSAS process, which led to the destruction of properties, including Lagos High Court building in Igbohere, as well as part of the Muritala Mohammed Airport. Further, that the defendant asked the floor to behead any military or police officers, and this led to the killing and beheading of a military couple in Olu, in Imo State. In addition, it was established that a retired judge, Honorable Justice Stanley Nnamdi, was also killed as a result of the defendant's broadcast. PW2 stated that the aim of the defendant was the creation of Republic of Biafra by any means possible, including war. Under cross-examination, PW2 stated that the video statement of the defendant was a complete reflection of what transpired during the interview, even though the camera was focused on only the defendant and his counsel. He stated that he does know if and how long the defendant was kept in solitary confinement prior to the statement being taken. He also said during the interview, defendant did not tell him that he was frustrated or angry. PW2 said further that he is not aware of the content of the charge against the defendant to know if any person was instigated or incited by the defendant to commit any crime. He also stated that he did not know if at the time of the DSS received exhibit PWF, the charges are already been pending against the defendant. PW2 stated that even though the governor of Southwest States formed the Amotekun group to tackle security in their region, he is not aware if the Attorney General of the Federation wrote to the DSS to investigate the activities, which led to the formation of Amotekun. He stated that he never listened to Radio Biafra, but only got reports from the DSS security platform, where people who are mandated to monitor same put their reports. PW2 said he was not part of the team that arrested the defendant, and he did not investigate the defendant's assertion that he was kidnapped from Kenya, as it was not part of what was minuted to him by his boss. PW2 explained that extradition is a process of bringing a person from another country to a country to start his trial. PW2 denies that an officer of DSS kidnapped the defendant in Kenya, since they are restricted to only Nigeria. He said Nigeria is a signatory to the United Nations Charter as well as the African Charter, and that many countries got their independence through agitation for self-government. He said there is no country today known as Biafra, even though the Nigerian Civil War was fought on the agitation of people of Southeast attempting to form their own country. He said he does not know if the defendant's home was attacked or that 28 persons were killed. PW2 stated that he visited some of the places that were destroyed as a result of the broadcast of the defendant, such as police station in Ebonyi State. Also, that he is not aware of the status of Sarara reporters and whether it is registered. He said the defendant confirmed that he ordered seat at home in the Southeast. PW2 confirmed that General T.Y. Danjuma, retired, has accused the Nigerian security forces of not being natural, of not being neutral. He said he is not aware that the Director General of DSS urged Nigerians to rise up and resist terrorists. He said he is aware that the NSAS movement was never classified as terrorist organization. He said the defendant was and remained a member of IPOD before and after it was prescribed by the court. Under re-examination, PW2 stated that Amotekun is not the same as Eastern Security Network, as Amotekun is recognized by law passed by the Houses of Assembly in the Southwest states, while Eastern Security Network is not registered, not recognized by any law, so it is an illegal association. PW3 is Mr. EEE is an operative of the State Security Service and have been with the agency for 27 years. According to him, the defendant is the leader and founder of indigenous According to him, the defendant is the leader and founder of Indigenous People of Biafra, a proscribed terrorist organization, and also served as the director and broadcaster of Radio Biafra, which was used to incite the public. He stated that his first contact with the defendant was on the 21st day of October 2015, when he was instructed to interview the defendant and to take a statement regarding the allegation about his activities in operating Radio Biafra, and also the founder of IPOP. He stated that on the first day, he invited the defendant to the DSS interview room at the national headquarters, where he and 3 other officers interviewed the defendant, and also video recorded of the interview, which defendant consented to. He said the defendant did not reduce his statement in writing until 23rd day of October 2021 due to complaint of his being tired and needing to rest on the 21st day of October. He said the written statements were then signed by the defendant when he finished writing. PW3 in his further testimony stated that during the interview of 24th day of October 2021, the defendant was confronted with video recording of interview with Sahara reporter. In that video, the defendant was resolute that there must be a change and the change will not come through peaceful means. PW4, Mr. DDD, also officers of the State Security Service and has been in service for 25 years. According to him, the defendant is the founder of IPOP, a terrorist organization calling for the secession of southern, southeastern, south, and states, and some parts of Benue and Kogi from the Federal Republic of Nigeria. PW4 stated that he got to know the defendant in October 2015 when he was arrested by officers of the DSS. He stated that allegations against the defendant include that he was agitating for the secession of Biafra and using Radio Biafra to incite members of IPOP against the Federal Republic of Nigeria. PW4 stated that further that on the 20th day of October 2015, through an intelligence, they discovered that the defendant smuggled a radio transmitter without clearing same to the Nigerian Customs Service, that it was hidden from view using household equipment and was contained in a container. PW4 stated that it was kept in the custody of one Benjamin Madubugu in Anambra. PW4 said he got to know all this when he was handed a video recording when the defendant was seen in the company of the said Benjamin Madubugu inspecting the radio transmitter and taking ownership and declaring it as a game changer, where Radio Biafra will be broadcast through. Following an instruction from his superior, PW4 obtained a search warrant and on the 28th day of October 2025 proceeded to the village where Benjamin Madubugu was and retrieved the radio transmitter. PW4 stated that when they opened the container, they found only the transmitter in it and asked Benjamin what happened to the other items, and he said the defendant came to inspect the radio transmitter with one individual named Chimeze, who took the other items away, leaving only the transmitter in the container. He said Benjamin Madugu wrote a statement on the 3rd day of November 2015 at the DSS headquarters, and he confirmed the result of the search. Benjamin Madugu, when asked, did not produce any custom paper. Benjamin was initially arraigned along with the defendant until he jumped bail and the case was severed. He said, IPOD has made life difficult in Southeast due to the sit-at-home order of the defendant, as well as the violence unleashed by IPOD. Further, the Eastern Security Network, which is the armed wing of IPOD, bears arms, engages in guerrilla warfare, where they attack security agencies such as the police and the Nigerian Army. They also ensure compliance with the sit-at-home order. PW4 stated that in a particular broadcast of 30th day of May 2021, the defendant issued threats that anyone who defies his order of sit-at-home by opening their shop should be killed and the shop burnt. PW4 explained that Ahmed Gulag, the former senior special assistant to the former President Goodluck Jonathan, was killed on the day declared to be a sit-at-home, that he tried to take another route to the airport in Owerri when he was shot by IPOD terrorists. PW4 said he was the first person at the scene and he found the lifeless body of Gulag on the road. He said that from the feedback they got from residents of Southeast, the sit-at-home order had depleted the economy and activities in Southeast, and the people were living in apprehension for their safety. PW4 also said that he knew one Ikonzo, identified as one of the dreaded commanders of Eastern Security Network, which renamed is Kanikayo Andy. He described Ikonzo as a ruthless commander who took direct orders from the defendant. PW4 further stated that Ikonzo was killed on the 24th day of April 2021 after masterminding attack in Olu, Imo State, during which he mobilized Eastern Security Network members and other adherents of IPOD to attack the correctional centers and facilitate the escape of numerous inmates who were in lawful custody. He also attacked the police headquarters, and a lot of police stations or police officers were killed. However, he was involved in a shootout with security operatives after a manhunt was declared on him. The shootout led to his death. PW4 stated further that on the following day, 24th day of April 2021, the defendant made a broadcast in which he declared that Ikonzo would be buried specially in the manner of the Oba of Benin, meaning that he would be buried with human heads. Consequently, the defendant's order is meant to procure human heads for the burial of Ikonzo. The order was carried out by one of his junior commanders named Emeriyi Uzoma Benjamin, known as Oye Ami. That when Oye Ami was arrested, he wrote in his statement that the defendant ordered him to get the heads, but he was only able to secure 30 human heads. At the scene of where the transmitter was kept in the premises of the Department of State Service, PW4 continued its evidence when he stated that the container containing this transmitter was recovered from the premises of one Benjamin Madugu, wherein the defendant had smuggled in the radio transmitter into the country. The container also had some household items in it, which were later removed. Upon the matter being adjourned back to the court, PW4 confirmed that Benjamin Madugu indeed made a statement before the DSS during the statement taking. He had his lawyer, one Vincent Obeta, present with him. PW4 also stated that upon retrieving the radio transmitter, they brought the defendant and Benjamin Madubugu together and confronted the defendant with the evidence. He stated that the defendant accepted ownership of the container and that the radio radio transmitter. He also exonerated Benjamin Madubugu by stating that the items were only kept in his house and that Benjamin Madubugu does not own the items. PW4 also stated that the DSS wrote to the Nigerian Broadcasting Commission to confirm and come and inspect the transmitter, which they duly came and wrote a report of the findings. The conclusion from the report as read by PW4 is that the station known as Radio Biafra was not licensed by the Broadcasting Corporation of Nigeria. Neither does he have any permits to operate in Nigeria. That for an organization to bring in a radio transmitter, it must apply for permission from the regulator, who is in turn right to the security agencies such as DSS and the National Security Advisor for clearance before the regulator issue a license to import this transmitter into Nigeria. That in this case, no such license permission was obtained by the defendant before importing this transmitter. PW4 referred to a newspaper story where the defendant had ordered an attack on prison in Owe, in Imo. The defendant had ordered members of IPOD to kill security operatives. Also, that investigation revealed that the defendant, having ordered members of IPOD to bury Ikozo in special way by using about 2,000 human heads. His men were only able to get 30 human heads. Efforts were made to arrest these IPOB members in Olu, in a village bordering Anambra Valley. They met some members of IPOB with human heads hanging from a wire mesh, and they also saw some of them eating human flesh, which they claimed was for spiritual fortification. They also saw as well where they dumped victims and beheaded bodies into. PW4 stated that it was part of the operation which comprised the DSS and the Nigerian Army. He also stated that the defendant has never denied making those state broadcasts and was even proud of making them. PW4 also stated that record shows that between 170 and 200 security agents of the federal government were killed by IPOB and Eastern Security Network all over Nigeria. He knows some of these murdered agents, which include his driver, one Shinemere Ereke, and their tactical leader who were killed in Umuma local government area of Imo State. PW4 stated that the defendant was in the habit of making inciting statements ordering his men to carry out attack on security agents as well as political figures such as Hope Uzodinma, the governor of Imo State. He stated that their mode of operation is that they move in group in Siena and others confiscated vehicles, and from there they launch attack on security operatives. They also set up checkpoints where they hijack other vehicles in good working condition. The group also engaged in activities aimed at terrorizing their community. That this group is so brazen that they even write to traditional rulers informing them of their intention to attack them. They attack even in broad daylight, kill people, burn down palaces and properties. PW4 continued its evidence by stating that the IPOB group are even more brazen in their attack on police stations like the one at Njamba local government area of Imo State. That they raided the station, killed everyone there, and turned it to their base. Similarly, the police station in Umoma in Oru East local government area of Imo State was sacked in the same way, and that the group even attacked a police headquarters where they shouted away arms and ammunition from the armory and burned down the place. He stated that on the 30th day of May 2021, the defendant had ordered a seat at home in Southeast, but the late Ahmad Gulad was unfortunate, caught in the storm as he was trying to catch flight out of Owerri that day. PW4 said he was the first to get to the scene of that attack where he found the disease in a pool of his blood. He was informed by the divisional police officer in the area that the disease was in a taxi heading for the airport when the iPod and Eastern Security Network armed combatants identified him as one of their checkpoints and opened fire on him. The driver of the taxi identified himself as an Igbo man, but the disease, even though he claimed he was an Igbo man, could not speak the language, and having observed a prayer mass, he witnessed firsthand the activities of the defendant and his men. PW4 stated that the defendant is the leader of indigenous people of Biafra, IPOB, as well as the founder and operator of Radio Biafra. He testified that the defendant used the said radio platform to incite members of the public to hate persons of other ethnic nationalities, particularly the Hausa Fulanis. PW4 further stated that through his broadcast, the defendant directed members of IPOB to attack and kill security operatives and to destroy infrastructures and symbols associated with federal government as part of his agitation for the establishment of Republic of Biafra under cross-examination. PW4 stated that he did not sign any of the investigation reports and also that the transmitter came in the country through the Tinkan port in Lagos. He said he did not find out the date the transmitter came into the country as same was smuggled into the country and that it was not part of his schedule to find out the date. That there are no records to show it came in through Lagos, save for the statement of the defendant that it came through the Lagos port. He also stated that IPOB was formed outside Nigeria and that Radio Biafra was operated outside Nigeria but broadcast within the territory of Nigeria as it was an online platform. He further stated that the defendant was arrested in Lagos with his broadcasting equipment. He said it is not the duty of the DSS to find out if Radio Biafra was registered in London. PW4 stated that he and one of the officers were sent to TVC News On to recover the transmitter that they reported to the DSS headquarters in Awka, and from there they proceeded to where the container was located using coordinates on video showing the containers. They testified that the container contained one other items including 2 pump-action guns, one of which was found in the bedroom of Benjamin Madubulu, that the said Madubulu is facing a charge of illegal possession of weapon before Inyako jail. He also stated that even though the defendant stated that he does not like violence and crime and that churches and other places of worship should not be attacked, his broadcast of 20th, 24th, 25th October 2020 clearly incited people to kill others. That the main cause of the defendant broadcast is the killing of Fulani herdsmen by raiding the forest of Southeast with AK-47, killing the innocent. He said he is not aware of any Fulani herdsmen being prosecuted for attacking people in Eastern states. PW4 admitted that Gulak conducted the primary elections that led to the emergence of the governor of Imo State, Hope Uzodinma, and that satisfaction over the declaration of Hope Uzodinma was still festering. He stated further that even though Ahmad Gulak was with 2 other persons in the taxi, he was the only one killed. IPOB sometimes do not kill Igbo person who violates the sit-at-home order. He admitted that the defendant said iPod will compensate the person which lorry of onions was hijacked, but he does not know if the promise was fulfilled by the defendant. PW4 stated that it was the police who investigated the killing of Ahmed Gulak. He said during the sit-at-home, everywhere, including farm, are usually deserted, and it is dangerous for anyone to be outside. PW4 also stated that the Nigerian Broadcasting Commission monitors the frequencies of every radio station in Nigeria, and they were able to monitor the frequency of Radio Biafra. He stated that the DSS could not arrest Abubakar Shekau due to him trying an explosive device to himself at the point of arrest. He said during his time in Southeast, he did not arrest any native doctor making sham for kidnappers. Also, that the checkpoints of police and the army are still functional in the Southeast today. PW5, Mr. EEE is an officer of this Department of State Service in the National Headquarters, Abuja. According to him, in July 2021, he was instructed to lead a team of officers of the police and the DSS, photographers and other investigators to travel around country to obtain and collect record of activities that occurred between 2020 and 2021 relating to the NSAS movements. He stated that the assignments included obtaining records from head of security agencies in the states visited, particularly the states in the Southeast and the FCT, obtaining reports of dates and death certificates of security personnel who died, as well as public properties destroyed as a result of NSAS protests and riots. PW5, while referring to Exhibit PWD2A, stated that 8 policemen were killed in Abia, 19 in Anambra, 13 in Ebonyi, 16 in Enugu, 16 in Imo, 17 in Akwa Ibom, 16 in Cross River. There were 6 police officers killed in Lagos, 9 in Rivers, bringing a total of 128 policemen killed. With respect to military officers, a total of 37 killed. The DSS had 10 casualties. A total of 167 police stations were destroyed during the protest. Then 9 INEC facilities were damaged and destroyed. Under cross-examination, PW5 stated that he only investigated the death of security operatives who were killed during the NSAS protest following the incitement by the defendant, who instigated protesters to kill security agents and even taught them how to manufacture Molotov cocktails to use in the process. He further said it is on record that the defendant urged protesters to destroy public buildings in places like Lagos. He said he does not know if one of the protesters, Aisha Yusuf, is sympathetic to Biafra or is a member of IPOB. He said he is aware that the police brutality was one of the causes of the NSAS protest and that the defendant urged people to take up arms against the government. PW5 said there is no part of the report stating the activities of IPOB or ESN. He also said all protocols relating to taking of photograph were duly observed. He said from pages 669 of the report, there are some visible dates on the photograph. PW1 stated that there is no portion of the document signed by himself as secretary of the Presidential Ad Hoc Committee of the committee that investigated the aftermath of the NSAS protest and the chairman of the committee. However, he stated that he certified the document and that the document was not certified after the proceedings of 12th day of June 2025. The defendant had filed a notice of preliminary objection dated and filed 16th October 2025, seeking for the following reliefs. 1. A declaration that they continue the prosecution of defendants under the repealed Terrorism Prevention Amendment Act 2013 upon a prescription under order obtained ex parte and without fair hearing violates Section 1, Sub 2, Section 36, 1 to 12 and 42 of the Constitution of the Federal Republic of Nigeria and Article 7 and 28 of the African Charter and is therefore null and void. 2. That a declaration that the Federal High Court ex parte order prescribing IPOB obtained without notice or hearing and why Justice Peter Inyako's sufficing ruling that IPOB is not an unlawful society remains in force, is unconstitutional, unlawful, and cannot grant criminality. 3. An order striking out or permanently staying count 1 to 8, saved count 15 of the amended charge dated 14th January 2022 for being barred by double jeopardy, having the same factual ingredient as count 6 to 14, earlier struck out by the Federal High Court on the 8th day of April 2022. 4. An order declaring that the defendant's extraordinary rendition from Kenya without extradition proceedings or due process violates Section 36, 1 and 9 of the Constitution, the Extradition Act, Cap E25, Law of Federation of Nigeria 2004, and Article 12 and 13 of the African Charter, thereby robbing the court of its jurisdiction. 5. An order nullifying all proceedings conducted in breach of the defendant's right to adequate facilities for defense, confidential communications with counsel, and for fair hearing, particularly dropping seizure of legal materials and denial of unmonitored access. The notice of preliminary objection has 43 paragraph affidavit deposed to by Ms. Emmanuel Kanu, a seedling to the defendant. The affidavit has 10 exhibits and a written address. In its written address, the defendant submitted inter alia that the Court of Appeal in CA/ABJ/C/625/2022 had ruled in his favor on the 13th day of October 2022, holding that his extraordinary rendition has divested the trial court from continuing his trial. Thus, the instant trial is unlawful and in disobedience of the order of the appellate court. The defendant relied on the case of Okafor versus AG Anambra State, citation supplied, to submit that any charge promised on repealed law cannot sustain and sustain any proceedings, that the provision under which his charge has been repealed by Terrorism Prevention Act 2022, and thus he has no life to sustain these proceedings. He also submitted that his extraordinary rendition, as well as not affording him adequate facility, denies him of his fair hearing, and thus he urged the court to quash the instant proceedings against him. He also argued that the court is divested of jurisdiction as the subject matter of this charge is sub judice before the Supreme Court. He does urge the court to uphold the preliminary objection. In written address filed on 30th day of October 2025, the defendants substantially repeated the submission in the notice of preliminary objection regarding the repealed law, extraordinary renditions, and denial of fair hearing. He therefore urged the court to quash the charge against him. The court formulates the following issue for determinations. After going through the evidence, the address of the defendants deemed to be final written address and that of the prosecution, the court formulates this issue. 1. Whether the defendant was denied his right to fair hearing in these circumstances of this case. 2. Whether the claim of extraordinary rendition of the defendants from Kenya invalidates the trial in this case. 3. Whether the provisions under which the defendant is being tried are repealed law and inoperative. 4. Whether the prosecution have established the charge against the defendant beyond reasonable doubts. Defendant has challenged the jurisdiction of this court as well as the competence and validity of the trial before this court. He premised his objection on the legality of the extraordinary rendition from Kenya in 2021, upon which he was brought back to Nigeria to face trial. He also raised an objection to the denial of his right to fair hearing, and that the charge was premised on repealed law, and thus the charge ought to be struck out against him. This court will painstakingly consider this jurisdictional issue before going to the substantive issue if need be. Jurisdiction is a general term referred to the extent of power and authority exercised by a court over a particular matter. It is seen as a threshold issue which determines how a court should handle a matter where jurisdiction is lacking. Any other action taken by the court amounts to nullity. Kindly see the position of my noble Lord Abiru, JSC, in NIMR versus Akin, Olugbade, and others. Citation supplied. Equally, see the enunciation by my Lord Ada, JSC, in Abu versus Sule, and others. Citation also supplied in this regard. On issue 1, with respect to the alleged denial of right to fair hearing of the defendant, the tenet of fair hearing is to the effect that both sides in a dispute must be heard as expressed in the Latin maxim or the alteram patem, that a party can not be a judge, or the alteram patem, and that a party cannot be a judge in his own court, as expressed in maxim nemo judes in casasua. Fair hearing is enshrined in Section 36(1) of the Constitution of the Federal Republic of Nigeria, and it provides in the determination of its civil rights and obligations, including any questions or determination by or against any government or authority, a person shall be entitled to a fair hearing within a reasonable time by a court or other tribunal established by law and constituted in such manner as to secure its independence and impartialities, unquote. Also see the case of MFA versus Inoga, citation supplied, where it was held, and I quote, fair hearing within the meaning of Section 36 of the Constitution of the Federal Republic of Nigeria 1999 means a trial or hearing conducted according to all legal rules formulated to ensure that justice is done to the parties. It requires the observance of two pillars of the rules of natural justice, namely, or the alteram patem and nemo judes in casasua. Simply means that no judge should decide over a matter in which he has personal interest or involvement, unquote. Also, my noble Lord, late Nikki Toby, GSC of blessed memory in INEC and Musa, citation supplied, heard and enunciated on the principle of fair hearing. The defendant claimed that he was denied his right to fair hearing by the court for closing him in the entry of his defense. As the risk of repeating myself, I will repeat my ruling of 7th November 2025, wherein I recounted the history of this case and proceeded to foreclose the defendants. This matter was filed in 2015, and due to the delay as a result of appeals and other issues, same was assigned to this court in March 2025. Prior to this, in 2017, the defendant was alleged to have jumped bail and escaped from Nigeria, and for about 4 years, the defendant was not in Nigeria within the territory of Nigeria, which caused a stop to his trial due to his absence. In 2021, he was brought back to Nigeria to face his trial. However, defendant became unruly and caused serious delay in the trial before my learned brother, Nnamdi. The issue got to a head that the defendant began asking my learned brother to recuse herself from the trial on the basis of being biased towards him. The judge recused herself, and the matter was assigned to this court in March 2025 for trial. Upon assumption of jurisdiction, having in mind that this matter has stayed for 10 years and the interest of justice, I granted a selected hearing. As a result of the selected hearing, I created morning and afternoon session in this court so as to accommodate this trial. The prosecution opened its case. In total, the prosecution called 5 witnesses and tendered several exhibits. The court ensured that the prosecution was kept on its toe during the presentation of this case, and same was closed on the 19th day of June 2025. It is worthy to observe that during the time when the prosecution was calling its witnesses, several adjournments were at the instance of the defendant. For instance, on the 29th day of April 2025, the defendant sought for an adjournment for cross-examination of PW1. Also, on the 2nd day of May 2025, the defendant counsel also sought for adjournment for continued cross-examination of PW1. Likewise, on the 18th day of May 2025, the defendant counsel applied for adjournment. In addition, on the 14th day of May 2025, defendant applied for an adjournment. Also, on the 21st day of May 2025, defendant applied for an adjournment as part of the options opened as part of options after the close of the case for the prosecution. The defense opted for the option of filing no case submission, which this court duly had after adoption of written addresses. Ruling was delivered on the 26th day of September 2025, wherein the no case submission was overruled. The issue of extraordinary rendition, validity of the charge, all were incorporated in the no case submission. After going through the no case submission, the court said, and the defendant was called upon to enter his defense. In the ruling delivered on the 26th day of September 2025, the court emphasized and laid importance to the issue of fair hearing, as contained in Section 36 of the Constitution, that the defendant shall be given opportunity to defend the charge he is facing. Upon this, the defendant was called upon to do so. The court in that ruling also pointed out the need for evidence to be given on oath, to give evidence on oath to challenge the evidence of the prosecution. In that no case submission ruling, the court mentioned the importance of the defendant to give evidence on oath because this is a criminal matter. It is not civil, where the standard of proof is on balance of probability. It is a criminal matter which the standard required under Section 135 of the Evidence Act 2011 is beyond reasonable doubt. It's worthy to note that extraordinary rendition is a quasi-criminal issue in a criminal case, and evidence on oath must be given, and the opposing side must be given opportunity to cross-examine on that quasi-criminal issue in accordance with Section 135 of the Evidence Act 2011. Also see the case of Edevie versus Orovore citation supply, where the Supreme Court held that where any allegation of crime or quasi-criminal are made in any matter, even in a civil matter, affidavit evidence will be insufficient and only oral evidence will be entertained due to the standard of proof being standard required in criminal matter, which is beyond reasonable doubt. These defendants had the duty to prove the allegation of extraordinary rendition in this criminal matter beyond reasonable doubt. The defendant has not called anybody to testify on oath in respect of extraordinary rendition, which would enable the other side to cross-examine such witness. The failure of the defendant to give evidence on oath on extraordinary rendition has made the allegation bare. It is simple and assertion without proof. The court was constrained to deliver the no case submission ruling earlier, as during the vacation of this court, the defendant has filed an application that he be moved to a private ward in the National Hospital, Abuja, as the facility of the Department of State Security Service were not adequate to take care of his health. The court had quickly rushed back due to the importance of health of the defendant. The court ordered the president of Nigerian Medical Association to constitute a panel of experts to carry out tests on the defendant to ascertain his health status and whether he is fit to stand trial. The need to ascertain his fitness to stand trial was based on the antecedents of causing delay in this trial. The court was suspicious whether the issue of medical reports raised at that stage was preemptive of the ruling and laying foundation for usual delay, which has been the trend since 2015. Based on this, the court added that the medical panel ascertained whether the defendant is fit to stand trial. It is actually a mystery to this court that a defendant who is standing trial would delay his own trial, while shouting that he is being denied his right to fair hearing. Usually, it is the prosecution that delays a trial as his life is not on the line. But in this case, the reverse was the case. The order of the court to ascertain his fitness was strategic to nip in the bud any attempt by him to further delay his trial. On the 16th day of October 2025, the court ruled on the medical report issued by the panel set up by the president of Nigerian Medical Association and determined that the defendant is indeed fit to stand his trial after no opposition from the defendant and the prosecution as regards the reports. The court had carefully observed the defendant during the entire trial and the spirited nature of the defendant. His unruly attitude and his agility in defending himself shows without that he is indeed fit to stand trial, thus corroborating the conclusion reached in the report by the panel set up by the president of Medical Association. Even without the medical reports, the fitness of the defendant is clear to any reasonable person who observed him in court. His claim of being low on potassium or other nutrients as stated in his supporting affidavit to his application for transfer to National Hospital are not such that render him incapacitated from understanding the proceeding in this trial. He is healthy, fit, and abreast of all the happening in the trial, and demonstrated full understanding and fitness after taking over his defense himself from his counsel. I therefore hold without doubt that the defendant is fit to stand this trial. The court then proceeded to give the defendant 6 consecutive days to open and close his defense. Counsel to the defendant, Chief Kanu had prayed the court to allow the private consultation between the defendant and his counsel in preparation for his defense. Despite the fact that there was no evidence before the court of the DSS dropping on the conversation of the defendant and his counsel, the court graciously asked the defendant and his counsel to use the courtroom for their pre-trial meeting, since they felt more comfortable in the court. The development meant that the court had to clear the courtroom, and it meant that the court could not conduct hearing in the morning of 22nd day of October 2025, just to accommodate the defendant and his counsel. The court then adjourned the hearing for 23rd, 4th, 24th, 27th, 28th, and 29th and 30th October 2025 for the defendant to open and close his defense. On the 23rd of October 2025, the learned C representing defendants including Kanu Agabi SAN, Onyechikpe Azu SAN, Polokoro SAN announced to the court that they wished to withdraw their appearances, as the defendant has indicated that he wanted to defend himself. The defendant confirmed the development and informed the court that he wished to represent himself at the trial. Upon exercising his right to defend himself, the defendant came on the next date, and his excuse was that he was not given his case file by his departing counsel. This was no doubt another cause of a delay on his part. The following day, the defendant appeared for himself and began challenging the jurisdiction of the court, arguing that there was no charge against him and that the medical report certified him fit was allegedly doctor. The court patiently explained to him that some of these issues he is raising have been treated in no case submission, and some of other issues could be raised during the final address. The court then advised him to engage counsel who are experts in criminal litigation due to the seriousness of the charge against him. The court also offered to secure the service of counsel from the legal aids or a private legal practitioner willing to take the matter pro bono, which were all rejected by the defendant. The court continued to appeal to him and even went as far as begging him in the name of God to please engage counsel and open his defense, all of which fell on the deaf ear. At a point, the defendant informed the court that he wanted to call about 28 persons as witnesses, some of whom he claimed are foreigners as witnesses in this case. He applied for witness summons. The court graciously immediately approved the witness summons. However, the defendant abandoned these said witnesses and began claiming that he had gone through the case file and he found that there was no law providing for the offences he is being charged with, that he could not defend a charge not found on a law. By this time, the defendant has still not opened his defense. Neither was there any seriousness on his part to put it in defense. The court, in discharging his duty to do justice, calmly and patiently advised the defendant to be cautious of the part he tended to take, as it was tantamount to resting his case on the part of the prosecution, which means that he admits the fact, evidence against him, but believes that it is insufficient to secure conviction against him. This court has been extremely patient and lenient with the defendant. He is only entitled to be given opportunity to defend himself as part of his right to fair hearing. Failure to use that opportunity granted by this court will be entirely his fault. He cannot complain thereafter of fair hearing. The right of a defendant to defend himself herself is a fundamental right, provided under Section 36 of the Constitution of the Federal Republic of Nigeria as amended. Such rights cannot be taken from a defendant except where a defendant expressly or by conduct waives same. See Segun Ogunsoya and the state citation supplied. The defendant refused to open his defense, despite the court informing him that it was minded to extend the day if he opened the defense on the 7th of November 2027. The court on the 27th of October 2027 made an order that defendant come on the next day to put his defense or file his final written address, or any written address filed by him will be deemed as his final written address in this suit. Pursuant to this order of the court, on the 27th October 2025, the defendant filed a motion on notice / comprehensive written address on notice on address on non-existence of a cognizable charge and the unconstitutionality of continuing of trial filed 30th of October 2025, and same will be deemed to be his final written address. That address is deemed as ordered by this court to be his final written address. The import of treating the written address as a comprehensive written address cannot be overemphasized. The word comprehensive, as used in that written address by the defendant, means, according to the online version of the Oxford Dictionary, is, and I quote, including, dealing with all, nearly all elements or aspects of something, unquote. The defendant in the motion on notice and comprehensive written address prayed for reliefs, including 4. The court to discharge him, which is a typical prayer in final written address in criminal matter? No doubt. The defendant clearly knew what he was doing by opting for final written address in form of motion/comprehensive written address in compliance with the order of this court made on the 27th day of October 2025. This will therefore be treated as the final written address of the defendant, and same have been treated and considered in the entirety. The defendant had also filed a notice of preliminary objection on the 16th day of October 2025. These two should be considered in the interest of justice, as the court having ordered that all preliminary objections will be determined in the judgments. Also, the preliminary objection filed on the 16th October 2025 is also considered thoroughly in these judgments. Another aspect of denial of fair hearing raised by the defendant is that he was misled into taking his plea in the charge. When the charge was read to when the charge was to be read to him, the court asked if he understood English. He responded that he did. When count 1 was read to him, he at first stated that he did not understand. The court ordered the registrar of the court to read the counts to him. He understood and took his plea. For the avoidance of doubt, I will reproduce part of the proceedings of 21st day of March 2025 when the plea of the defendant was taken. Registrar Nnamdi Kanu, do you understand and speak English language? Defendant, I do. Yes. Registrar, listening to the charge against you. Count 1. Registrar, after reading, do you understand count 1 I read to you? Defendant, I don't. Courts, take it again. Count 1. Registrar, after it, do you understand count 1 I read to you? Defendant, I do. Yes. Registrar, are you guilty or not guilty? Defendant, not guilty. Count 2. Defendant, do you understand count 2 I read to you? Defendant, I do. Registrar asked him, are you guilty or not? Defendant reacted, I'm not guilty. Count 3. Registrar read to him and asked him, defendant, do you understand count 3 I read to you? Defendant, I do. Registrar asked him, are you guilty or not? Defendant responded, I not guilty. Count 4. Registrar read and asked him, do you understand count 4 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not guilty? Defendant responded, not guilty. Count 5. Registrar read and asked him, do you understand count 5 I read to you? Defendant responded, I do. Registrar, are you guilty or not? Defendant responded, not guilty. Count 8, now count 6. Registrar read and defendant, do you understand count 6 I read to you? Defendant said, I do. Registrar, are you guilty or not? The defendant responded, not guilty. Count 15, original 15, now count 7. Registrar read and said, defendant, do you understand count 7 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not? Defendant responded, not guilty. The defendant clearly understands English language, being an educated man. On that day, he had his counsel, including senior advocates such as Kanu SN, representing him on that day. The court complied with the procedure of taking the plea of the defendant in accordance with section 271, 2, and 3 of the Administration of Criminal Justice Act 2015, which provide thus: 1. The defendant to be tried on a charge or an information shall be A. brought before the court unfettered unless the court says cause otherwise to order, and the charge and information shall be read over and explained to him to the satisfaction of the court by the registrar or other officer of the court. B. Called upon to plead instantly unless where the person is entitled to service of the information he objects to the non-service, and where the court finds that he has not been duly served. 3. The court shall record the facts that he is satisfied that the defendant understands the charge or information read over to him and explained to him in the language he understands, and shall record the plea of defendant to the charge or information as nearly as possible in words used by him. Looking at the above statutory provisions of Administration of Criminal Justice Act, the procedure adopted by this court, the defendant cannot turn round to claim he was misled to take plea after the prosecution has closed his case. It is nothing but the usual habitual flaw of the defendant to cause delay and make the matter to start de novo. This court will not allow matter to be on its court list ad infinitum. On the issue of denial of adequate facilities, the defendant claimed that he was not allowed to consult with his legal representation in confidence at DSS, as the DSS officers were dropping on their conversations. The defendant is facing criminal trial and is entitled to the right to adequate time and facility in preparation for his defense. He enjoys the constitutional right to fair hearing, and in consequence to this right, has the right to adequate facilities as his defense. Section 36 6B of the Constitution of the Federal Republic of Nigeria 1999, as amended, provide every person, I quote, every person charged with criminal offence shall be entitled to be given adequate time and facility for the preparation of his defense. See the position of the Supreme Court in respect of this provision as initiated in Igwe and the state. Citation supplied. As part of the package of rights available to a person facing criminal charge, he is entitled to all the facilities and enough to time for purpose of preparing his defense. This ties in with the right to presumption of innocence under Section 36(5) of the Constitution of the Federal Republic of Nigeria 1999 as amended, which stipulates that until a person is declared guilty by a court of law, he is presumed to be innocent. The provision was the subject of interpretation by the Supreme Court, particularly by my noble Lord Akat JSC in Okoye and COP. Citation supplied, where my Lord said, and I quote, the moment an accused person is facing a charge, his personal liberty is at stake, and before that liberty is taken away, he must be afforded every opportunity to defend himself. Once he becomes aware that he has a charge hanging upon his neck for an infraction of the law and makes a request either orally or in writing for any facilities to prepare his defense, the court must accede to his request and the prosecution has to comply. The facility that must be afforded the accused person are the resources, anything which will aid the accused person in preparation of his defense to the crime for which he is charged. This, no doubt, includes the statements of the witnesses interviewed by the police in the course of their investigation, which might have absolved the accused of any blame or which may assist the accused to support such favorable witness that the prosecution counsel may not want to put forward for to testify, unquote. See case of Nweke and the state. Citation supplied. The defendant did not provide any credible evidence as to this allegation of airdropping. The court, however, in order to do justice to him and suspecting that he was looking for another way to delay this trial, allowed him to consult with his lawyer on the 22nd day of October 2025 in the courtroom. Thus, the court had to vacate the courtroom for him, his lawyer to use. Despite this magnanimity by the court, the defendant did not make use of this opportunity. On the following date, the counsel withdrew his appearance. The defendant decided to defend himself, making the opportunity given to him to use the courtroom to be useless and of no purpose. Despite the fact that he is not a legal practitioner, he began using some of his counsel who he had earlier disengaged to act as legal consultants to him. The court even kindly ordered the DSS to allow these consultants have free access to him. This is in compliance with Section 36 of the Constitution of the Federal Republic of Nigeria, which provides for access to legal practitioners. Most of these legal consultants were always present in court. There is nothing to show that he was denied adequate facilities to prepare for his defense. He had enough time to prepare. He had been represented by senior advocates such as Kanu and Nnamdi SAN, Onyeshi Impe Azu SAN, Emeka Ikpabas SAN, Paul Urokoro SAN, how do not get SAN among others before they were suddenly disengaged. And the defendant decided to represent himself, which this court suspected was also to cause another delay in the hearing of this matter. His allegation holds no water in the light of the facts and circumstances in this case. Consequently, this issue is resolved against the defendant. On the issue of extraordinary renditions, there are instances where a person commits offense against a country while residing in another country or flee the country soon after committing the same crime. In such instances, the country against which the offense is committed will request the country in which the suspect is residing to release him to it. The process is known in law as extradition. Extradition therefore refers to a legal process in which a state renders a person accused of committing a crime to the state against which the crime was committed, known as requesting nation. The Supreme Court in AG of Federation versus Nnamdi citation supply subsequently explained the concept of extradition as follows. Extradition is a cooperative legal process of one state called the surrendering state or authority which renders an individual to another state called the requesting state for prosecution or for punishment for crime committed within the requesting country jurisdiction. Extradition process is usually spelled out in bilateral or multilateral extradition treaties or agreements. Extradition becomes necessary when a criminal fugitive flees from one country to another to avoid facing trial or punishment. Persons who may be extradited include those who have been tried and convicted but escape custody by fleeing the country, and thus convicted in absentia. A trial in which the accused person is not physically present. Extradition is distinguished from other modes of forceful removing undesirable persons from a country, such as exile, expulsion, deportation. Extradition procedure are usually determined by the terms of the treaties between individual countries or by multilateral agreements between group of countries, such as the Commonwealth countries or the countries of the European Union. The receiving government then refer to its law. Its treaties specify obligations to the requesting nation and decide whether or not to extradite the persons named in the warrant. Treaties signed in recent decades tend to take a dual criminalities approach, classifying and extraditable offenses that are punishable in both jurisdictions. Other extradition treaties, by contrast, tend to list covered offenses, unquote. Usually, the requesting and surrendering nation have a treaty or agreement which allows for such transfer. Nigeria, for instance, is signatory to regional agreements like the ECOWAS Convention on Extradition and other multilateral schemes, such as the London Scheme for Extradition, which within the Commonwealth. The London Scheme for Extradition within the Commonwealth enables Nigeria to request and surrender fugitives to member nations of the Commonwealth. On the other hand, extraordinary rendition is an extrajudicial measure to forcefully bring suspect or defendant to the country against which an offence is committed. These extraordinary measures may include adoption. The Supreme Court of Nigeria alluded to this in the case of Federal Republic of Nigeria versus Nnamdi Kanu in SC/CR/13C1/2022, where my noble Lord Agim JSC held, and I quote, "Generally, abduction or kidnapped or any form of illegal removal of an accused from the territory of a state to another to face criminal trial or for a reason is prohibited by law. Extraordinary rendition or any other transfer without due process is unlawful. There is no doubt that the illegality in the process of bringing the respondent to Nigeria for the criminal case brought by the appellant against him in Nigeria, the attendant massive violation of his rights, render his prosecution by the appellant unfair and oppressive. While extraordinary rendition measures may, unquote, while extraordinary rendition measure may seem illegal on the face of it, the way and manner in which the attendance of a defendant is secured does not vitiate his trial. In the United States of America, this is known as Kelfibril doctrines. This doctrine developed through the case law, notable cases of Kel versus Illinois, 119 U.S. 436 1886, and the case of Freebly versus Collins, 342 U.S. 519 1952, where a messenger forcefully kidnapped the defendant from Peru and brought him back to the United States, even though he had been sent to Peru with a valid warrant and instructions to obtain the defendant with the cooperation of the local authority. Addressing Kel's due process challenge, the Supreme Court of the United States held that, and I quote, "Such forceful abduction is not sufficient reason why the party should not answer when brought within jurisdiction of the court, which has the right to try him for such an offence, and presents no valid objection to his trial in such case." In Freebly's versus Collins, 342 U.S. 519 1952, it was a case where the defendant was tried and convicted in the state of Michigan after being adopted by Michigan authority from Chicago, Illinois, applying its decision in care. The Supreme Court upheld the conviction of the conviction over challenges based on due process and federal kidnapping law. The essence of Kel's Freebly doctrine is that even though the act of rendition is illegal, a trial court may assert jurisdiction over the person regardless of the legality of the adoption under international law. In recent times, the Supreme Court relied on Kel's Freebly doctrines in United States versus Alvarez Merchant in 504 U.S. 65 1992. Alvarez Merchant, a Mexican citizen, was adopted and brought to the United States at the direction of the Drug Enforcement Administration. The Supreme Court of the United States held that despite his forceful adoption from Mexico by United States officials, it did not affect the validity of his trial in the United States. As said earlier, the issue of extraordinary rendition is quasi-criminal issue, which must be proved beyond reasonable doubt in accordance with Section 135 of the Evidence Act 2011. The law in Nigeria is strict that even a civil matter, once a criminal element is introduced, it must be proved beyond reasonable doubt. For instance, where an allegation of forgery is introduced in a civil proceeding, the standard of proof is proved beyond reasonable doubt. See the case of Minister of FCT versus Finance Consultancies Services Limited and another, citations to supply, where the Court of Appeal held, and I quote, "Every forgery involves an alteration of documents, but not every alteration of documents amounts to forgery. Forgery involves alteration with a fraudulent intent. The fact and incident of forgery must be specifically pleaded and proved even in civil matters, as in this case, beyond reasonable doubt. The appellant in this appeal has made allegation of forgery, but failed to prove same. In a case of forgery, both the original document and the fake must be produced in court for examination. The appellant failed to produce any document in proof of these forged documents. Allegation of such forgery in any civil matters is criminal in nature. Therefore, proof is beyond reasonable doubt." See also the case of Muni versus Federal Republic of Nigeria, among other authorities. The evidence in proving an unlawful extraordinary rendition must be oral evidence obtained, which allows the adverse party to cross-examine the defendant on his oral evidence. The defendant only swore to an affidavit. So the fact that the affidavit evidence is best used in civil proceedings, where the standard of proof is on balance of probability. The affidavit filed by the defendant is grossly insufficient to establish if indeed he was extraordinarily rendited or he was illegally brought to Nigeria. The gaps in evidence will therefore mean that no evidence was led regarding the extraordinary rendition. Assuming, without conceding, that there was evidence regarding the extraordinary rendition, the court will consider the effect of the extraordinary rendition on the validity of the trial of the defendant. The defendant, in his written address, has argued strenuously that the way he was brought back from Kenya was illegal and thus vitiates his trial before this court. He relied heavily on the decision of the Court of Appeal in Federal Republic of Nigeria versus Kanu, in appeal number CA/ABJ/CR/625/2022, delivered on the 13th day of October 2022 on the issue. The court held, and I quote, "The consequence of this session, I hold that the respondent is prohibited from being detained, tried, or otherwise dealt with in Nigeria for or in respect of any offence allegedly committed by him before his extraordinary rendition to Nigeria. The lower court thus has no jurisdiction. I further hold to try the appellant on counts 1, 2, 3, 4, 5, 8, and 15, which were retained by it, being charges allegedly committed by the appellant prior to his extraordinary rendition. In addition, by the forceful adoption and extraordinary rendition of the appellant from Kenya to the country on the 27th day of June 2021, in violation of international and state law, the lower court or indeed any court in the country is divested of jurisdiction to entertain charges against the appellant, and I so hold, unquote. When this issue came up before the Supreme Court, the apex court, in Federal Republic of Nigeria versus Kanu, in SC/CR/1361/2022, delivered on the 15th day of December 2023, the apex court held per ML Gaba JSA, and I quote, I quote my noble Lord M.L. Gabbard, JSC. I agree with the learned senior counsel for the appellant that the procedure used in bringing or producing the respondent before the trial court for the trial of the offences in the counts of the charge in questions in respect of which he was validly arraigned did not affect or even go to the statutory jurisdiction of that court to proceed with that trial. The procedure, mode, manner by which the respondent was produced before the court is in before the trial court is in law extraneous to the statutory jurisdiction vested or conferred on the trial court to try or adjudicate over the offences in question, particularly after the valid arraignment of the respondent and his plea thereto. The procedure used in producing the respondent to face his trial after the arraignment and plea to the offences and after jumping the bail granted to him by the trial court cannot reasonably be said to deprive or rob that court of the requisite statutory jurisdiction to adjudicate over or try the offences in question. In the above premises, the lower court, which is with the respect due to it, took its eye off the balls when it filed off the statutory jurisdiction vested or conferred on the trial court to subject it to procedural law dealing with the procedure for the arrest, extradition, or rendition of runaway fugitive offender to and from the foreign country. The provision of Extradition Act Cap E25, Laws Federation of Nigeria 2004, articles and parts of the UDHR 1964 and pronouncement of foreign courts on them referred to and solely rely on by the lower courts to hold that the procedure used or employed to produce the respondent before the trial court to continue his trial had robbed that court of jurisdiction to adjudicate over or try the offences in question, did not create, define or punish the said offences, neither did any of them conferred or vest the statutory judicial power and authority or jurisdiction to try adjudicate over the offences in respondent was charged with and validly arraigned for. Rather, they all merely provide or prescribe for the general procedure to be adopted in respect of their respective subject matter that do not include and have nothing to do with creating, defining, or punishing offences and vesting or confining judicial power and authority or jurisdiction on courts to advocate over or try such offences. Once again, these laws and rules, conventions, etc., do not take away, deprive, or rob the jurisdiction of the trial court to adjudicate over or try the offences the respondent was arraigned for on the basis of procedure used or employed to bring or produce him before the trial court for continuation of his trial. I must emphasize that even this court, as the apex court in Nigeria, cannot, by pronouncement, take away, deprive, or even fetter the jurisdiction or conferred or vested on the court of record by the constitution or a statute, let alone pronouncement by foreign courts on such foreign international convention, treaties, and agreements, or even if domesticated. In this result, the issue is resolved in favor of the appellant to the effect that the trial court is statutorily vested or conferred with the requisite jurisdiction to adjudicate over and try the offences in the retained count of the charge the respondent was validly arraigned for, and that the procedure used and employed to bring or produce him for the continuation of his trial did not rob or deprive that court of jurisdiction. It was an error in law for the lower court to resort to and hold that the procedural law or entirely different subject matter of arrest, extradition, or rendition of runaway fugitive offenders accused persons from foreign country deprived or robbed the trial court of the statutory jurisdiction. My Lord arguing in the same case also adds, and I quote, the established case law through the cases is that even though a strict alliance to statutory prescriptions concerning pre-trial criminal processes, the processes for bringing the accused to court for trial is a sine qua non for fair trial. Violation of the fundamental rights of an accused person or other unlawful action by the prosecution at the pre-trial stage give the accused person the right to action for remedy for violation of his fundamental rights and other civil remedy, and has no effect on the validity of the whole criminal proceedings against him and the jurisdiction of the court to entertain the proceedings and try him, provided the facts alleged against him disclose an offence created by written law and a reasonable basis for suspecting he committed the offence. So the established case law in Nigeria is that violation of fundamental rights of an accused person and any illegality in pre-trial or extraordinary process in relation to an accused person should not affect jurisdiction of the court to try ensuring criminal cases and the validity of such case. That is the basis for the admission of relevant evidence obtained from illegal searches and seizures or searches that violates the accused person's fundamental right to privacy. In Nigeria, there is hardly any case where the jurisdiction of a court to try a case is declared to be ousted by or validity of the case declared vitiated by the unlawful arrest and detention of an accused person at the pre-trial stage of that case or by any unlawful extrajudicial action of the prosecution after arraignments during the pendency of the proceedings in court. The Court of Appeal has introduced a departure from the established case law on the points in Nigeria. What is not clear is if the departure is limited to cross-border cases or include cases within Nigeria. But the erudite restatement of the House of Laws in Howard versus Osprey relied on by Court of Appeal are couched in terms that suggest that they apply to all cases. This profound judicial restatement appears to give paramount consideration to preventing executive lawlessness, protection of the fundamental rights of the accused, preservation of the rules of laws, promotion of rights for territorial sovereignty of states, enforcement of international law, adherence to due process of criminal law to ensure that prosecution does not benefit from abuse of its power and abuse of court process. But the reality in Nigeria's peculiar situation is that no allegation of commission of a crime will be tried if the court declines jurisdiction to try a criminal case or invalidate it because of the violation of fundamental rights of the accused person or other unlawful action of the prosecution that occur in the process of investigating a criminal complaint against him or in the process of initiating the criminal case arising from such complaints or in process of bringing him to court or in dealing with him while he is standing trial. This is because criminal law enforcement officers routinely engage in unlawful actions and brazen violation of fundamental rights of suspects in the investigation and prosecution of virtually all criminal matters. The effect of the holding of the Supreme Court is that, notwithstanding the legality or otherwise of how the defendant was brought back from Kenya, it does not invalidate his trial. The court will curtail the line set by the Supreme Court as the apex court of the land. His decisions are final, override all other courts, including the Court of Appeal, which defendant has erroneously relied on heavily. Kindly see Section 235 of the Constitution of the Federal Republic of Nigeria 1999 and the case of Adama Tanker Brokering Services Limited against CBN citation supply. The fact in this case is more distinguishable. The fact in this case is more distinguishable even than in Kev Fibri case in US. with respect to the effect on the jurisdiction of court to try the defendant as held by the Supreme Court per Gaba JSC. In that case, the defendant was already arraigned before this court, and in this case, the defendant was already arraigned before this court, and the jurisdiction of this court had been activated as far back as 2015. More so, he had been compensated monetarily in suits he filed in Kenya, unlike in Kel Freebridge case, where the defendants were not on trial before their rendition. Despite the fact that in Kel Freebridge they were not arraigned before the extraordinary rendition, their trial were not invalidated in US. The defendant in this case, on being granted bail, was alleged to have John bail by leaving Nigeria, and for 4 years. The trial was granted until he was rearrested in 2021 in Kenya. This action of the defendant makes him a fugitive. In this case, the trial has begun, and the charge has been filed and read to the defendant before the alleged extraordinary rendition. He cannot then claim that the trial is vitiated by the extraordinary rendition. The alleged rendition of 2021, the jurisdiction of the court activated since 2015. I hold without hesitation that this is an exception to the effect of extraordinary rendition in international law. Even if the extraordinary rendition was wrongful, the remedy for it is at best monetary damages in civil proceedings. The court is aware that a court in Kenya had ruled on this issue and awarded monetary damages to the defendant. The court in Kenya had awarded monetary damages against the Kenya government for gross violation of defendant's rights, fundamental rights. The defendant cannot benefit from monetary damages awarded to him and seek a further relief of his trial being vitiated, particularly seeing the nature of the offences, which borders on terrorism. This is similar to the enforcement of fundamental rights to personal liberty in Nigeria. A successful application for unlawful arrest entitles the applicant to compensation or an apology, but it does not extend to vitiating a criminal trial where the charge has been preferred against him. Consequently, this issue is resolved against the defendant. On issue 3, the defendant has challenged this court, arguing that it is based on repeat law. The general rules regarding a charge is that it must be premised on written law. See section 36, sub 12 of the Constitution of the Federal Republic of Nigeria, and it provides, and I quote, subject as otherwise provided by this Constitution, a person shall not be convicted of any criminal offense unless that offense is defined, and the penalty therefore is prescribed in a written law. And in this subsection, a written law refers to an act of National Assembly or a law of states, any subsidiary legislations, instrument under the provision of the law, unquote. The above means that a person to be tried and convicted, the offense must be in existence and provided for under law, a law in force at the time. See the position of the Court of Appeal in Daniel versus Federal Republic of Nigeria, citation supplied. The law is also settled that the trial and conviction of any person upon the repeat law is a nullity. This was the position of the Court of Appeal in IGP versus Ogundimu, citation also supplied. A law, once repealed, ceases to have any life and must be treated as dead. And the Supreme Court in State versus Egigia has initiated on this, and I quote, the law is settled that a repeat law no more has legal life. Thus, it cannot be cited as if it still exists. If it must be cited at all, it must be cited as a repeat law, which has no life to influence an argument. A repeat law cannot be the basis for any comparison with existing law. It cannot be quoted side by side an existing law, as learned advocates did, unquote. Now, the defendants argued that the Terrorism Prevention Act 2013 had been repealed by the Terrorism Prevention Act of 2022. Thus, the trial has become spent. The argument by the defendant is quite interesting. It is interesting because it shows the stark misunderstanding of the law by the defendants, as well as his willful disregard of the facts accumulating in his trial. Firstly, the defendant is charged under the Terrorism Prevention Amendment Act 2013. The extant charge is as to offences allegedly committed by the defendant between 2018 and 2021. As at when the extant charge was filed, the Operational Terrorism Act in Nigeria was the Terrorism Prevention Amendment Act 2013. That act was duly passed by the National Assembly and signed into law by the President, Goodluck Jonathan. It empowered the court to try terrorism-related offences and also outline what constitutes act of terrorism. Under Section 30 of the 2013 amendments, the Act provides thus, and I quote, "The Federal High Court located in any part of Nigeria, regardless of where the offence is committed, shall have jurisdiction to try offences under this Act." Unquote. Section 1(2) of the same law defines terrorism as follows, and I quote, "Any act deliberately done with malice aforethought which may seriously harm or damage a country or an international organization is intended to intimidate a population, compel a government to act or abstain from acting, destabilize a fundamental political, constitutional, economic, or social structure of a country," unquote. The above provisions were enforced 2 years before the defendant's arrest in 2015, meaning this court had requisite jurisdiction to try him then. His initial trial, therefore, was based on an existing and valid legal foundation as at then. This instance means that at the time he was charged, the Terrorism Prevention Amendment Act 2013 was the extant law of the land. It would have been different if the defendant's offences were allegedly committed after the Terrorism Prevention Act 2022 have been enacted. The Terrorism Prevention Amendment Act 2022 comes into effect on 12th day of May 2022, which is a later date compared to when the alleged offences were committed. The Supreme Court in Federal Republic of Nigeria versus Kanu Supra, the present defendant in this case also ruled on that issue and held, and I quote, "Now, even a casual look at the offences stated in count 1, 2, 3, 4, 5, and 8 of the charge pleaded to by the respondent before the trial court readily shows that they are offences provided for in 2011 Act as amended and by the 2013 Act under which the charge was filed and brought, and the respondent was properly and validly arraigned before the trial court. Put another way, the offences the respondent was arraigned for before the trial court are offences known to and specifically provided for under and by the provision of 2011 Act as amended by 2013 Act. The offences are therefore recognized, cognizable in law, to be legally grounded and backed by the provision of extant and existing law that was / is in force at the material time and now. On its part, count 15 of the charge is indicated to be contrary to section 47(2)(a) of the Criminal Code Act, cap C45, Laws of the Rendition of Nigeria 2004. There can be no reasonable dispute that the criminal code is an existing statute or act that was or is in force in Nigeria, which the court has the duty to take judicial notice in this appeal, pursuant to provision of Section 122 of the Evidence Act 2011. In addition, the court is also entitled to take judicial notice of the codification and publication of all the acts or statutes, the subsidiary legislations, enactments or passed by the National Assembly as contained in the laws of the Federation of Nigeria, published by or under the authority of the Federal Ministry of Justice of Nigeria at various times, because we here are concerned with laws of Federation of Nigeria 2004, in which the Criminal Code Act is indicated to be. I have noted and pursued the laws, perused the law and acts codified and published in the laws of Federation 2004 as published. The Criminal Code Act is published in Volume 4, comprising of Chapter C24 to Chapter C48. It is in Chapter C38, which is subsequently indicated as Cap 38. The Criminal Code Act is in Chapter 38 of the Laws of Federation of Nigeria 2004, and it's also called or shown to be Cap C38 in Volume 4 of the publication. It is apparent, therefore, that the Criminal Code Act is not Cap 45 or Cap C45 in Volume 4 of the Laws of Federation of Nigeria, as indicated in Count 15 of the charge against the respondent. Rather, Criminal Code Act is Chapter 38 or Chapter C38 in the Laws of Federation of Nigeria 2004. However, the same Laws of Federation of Nigeria 2004, Chapter 45 or Cap C45 is the Custom and Excise Management Act. A calm reading of the details of the facts stated as constituting the offense mentioned or named therein will clearly and undoubtedly reveal that it deals with offense punishable under the provision of Section 47(2)(ba) of the Custom and Excise Management Act C45, Laws of Federation of Nigeria 2004, which provide as follows. 47(2) if any person A imports or causes to import any goods or conceal in a container holding goods of different description, he shall be sentenced to imprisonment for 5 years without the option of fine. It follows, in the above circumstances, that the mention of the Criminal Code Act as being Chapter C45 and C45 in Laws of Federation 2004 is a mere mistake in place of correct law. The Custom and Excise Management Act, under which the facts alleged to constitute an offense in Cap 15, is punished or punishable. The offense in Cap 15 is consequently recognizable, and grounded in an extant existing law in Nigeria, in which it was defined and described. It is now unbooked law that a charge preferred or filed for offense under a wrong law will not be rendered invalid or incompetent merely on that ground alone, so long as the offense on the charge are known to defined and punishable punishment provided for in an extant law. In the results, the answer to the answer posed earlier in this affirmative in both two counts, that the Terrorism Prevention Amendment Act 2013, under which the offences of count 1, 2, 3, 4, 5, and 8 as well as Cap C45 and Cap C45, Custom and Excise Management Act, all contained in Laws of Federation of Nigeria 2004, are extant and existing law, which provide for, under which the offences in the counts of the charge retained by the trial courts are punishable and punished. The offenses once more are recognized, cognizable, and ground instance and existing law in force in Nigeria. Assuming without considering that at the commencement of the Terrorism Prevention Amendment Act, the Terrorism Prevention Amendment 13 was repealed, and such is liable to affect the validity of the defendant's trial. I refer to Section 98 of the Terrorism Prevention Amendment Act 2022, which provides 98.1. The Terrorism Prevention Act number 10, 2011 is repealed. 2. Any regulation, order, requirements, certificates, notice, direction, restrictions, authorizations, consents, applications, ongoing cases in courts, requests or things made, issued, given, or done under the repeat act shall, if in force at the commencement of this act, continue to be in force and have effect as if made, issued, given, or done under the corresponding provision of this act. 98.3 provides any proceedings, prosecutions, sentence, judgments, charge, or course of actions pending or existing immediately before the commencement of this act under any of the repealed acts in respect of any rights, interest, obligation, or liability may be continued and commenced as the case may be, and any determination of any court of law, tribunal, or other authorities or person may be enforced to the same extent that such proceedings, prosecutions, sentence, judgments, charge, course of actions, or determination might have been continued, commenced, or enforced as if the act has not been made, unquote. The imports of this provision, particularly section 98.3, it serves as a saving provisions which ensure that the amendment of the act does not affect the validity of trial begun under the repeat act. This saving clause or preservation provision is aimed at ensuring that pending proceedings or order of courts are not washed away as a result of the commencement of the amended Act 2022, but to ensure a smooth transition from the repealed Act to the amended Act. The sum total of this is that the enactment of the Terrorism Prevention Amendment Act 2022 does not vitiate the trial of the defendant rightly commenced under the Terrorism Prevention Amendment Act 2013. Consequently, this issue is resolved against the defendant. With respect to the substantive issue, I must start the resolution by outlining the effects of the action of the defendant in failing to put in his defense despite several opportunities afforded him by this court. Generally, in criminal trial, the defendant has the three options available to him. Upon the closure of the prosecution case, he has the option of making a no-case submission to argue that the prosecution has not made out a prima facie case against him to warrant him to enter his defense, or that the evidence led by the prosecution so far had been so discredited under cross-examination that it would be unsafe for the court to convict him. Another option open to a defendant is to put in his defense where he will be opportune to state his side of the story as well as present exculpatory evidence in his favor. The third and the final option is to rest his case on that of the prosecution. The defendant in this case choose to make no case submission, no case submission, and this court overruled his no case submission on the 26th day of September 2025 and ordered him to put in his defense. It is his constitutional right to do so. He, however, refused to do so. He rather consented to the withdrawal of his learned senior counsel representing him, despite the court employing him to enter his defense on several occasions, even begging him, in the name of God, as a minister in the temple of justice, passionate about justice, as an apostle of Jesus Christ, I begged the defendant passionately and severally, but the defendant was obstinate and refused, and the court had no choice than to foreclose him. The effect of this is that the defendant has chosen to rest his case on that of the prosecution. The defendant this morning confirmed this fact by saying that he has put in his defense. The effect of the defendant resting his case on the prosecution is that it is a gamble, a risky option, which may boomerang if the evidence adduced by the prosecution is believed by this court. The Supreme Court in Adamu and States, citations supplied, held, and I quote, "The law is generally settled that an accused person who, at the close of prosecution case, decided to rest his case on that of the prosecution as presented against him is only exposing himself to risk and gamble. The reason being that if the case is such that even if all the prosecution witnesses are believed, yet the offense as charged is still not proved, then the accused may get away with the risk of resting his case on that of the prosecution. By that choice, the accused will have decided not to explain any fact in rebuttal of the allegation made against him." See also the position of the Supreme Court in the case of Ajibade and State citation supply, where the court held, and I quote, "Appellant elected not to give evidence in his defense, but to rest his case on that of the prosecution. The election is within his rights under the law, but the legal effect of the said election is to leave the court of trial free to accept the uncontroverted evidence of the prosecution in proof of the charge, which the court rightly did, in my view," unquote. See also the case of Hakim Idisseyin versus Olajide, citation supplied. The defendant in this case deliberately refused and failed to call any witness and present evidence through his witnesses in rebuttal of the case of the prosecution. The implication is that he admits the case of the prosecution, and the court is entitled to rely on the uncontroverted evidence led by the prosecution. With respect to count one of the charge, the defendant is facing a charge of committing an act in furtherance of an act of terrorism against the Federal Republic of Nigeria by making a broadcast received and heard in Nigeria with intent to intimidate the population and threaten that people will die and the whole world will stand still, thereby committing an offense punishable under Section 1(2)(b) of the Terrorism Prevention Amendment Act 2013. The same section provides a person or body corporate who knowingly in or outside Nigeria, directly or indirectly, willfully commit an act preparatory to or in furtherance of an act of terrorism, commits an offense under this act and is liable on the conviction to maximum of death sentence. The ingredients of the offense as drawn from the above are: 1. The defendant must be a person or body corporate. 2. The defendant must have done an act preparatory to or in furtherance of an act of terrorism. 3. The defendant must have done the act preparatory to or in furtherance of terrorism act knowingly or willfully, and same may be directly or indirectly. See the case of Ada versus Federal Republic of Nigeria, citation supplied. Looking at the first ingredient, there is no doubt that the defendant in this case is a person. He is known as Nnamdi Kanu. The man is in 50 who stood trial before this court. Thus, the first ingredient is resolved in favor of the prosecution. For the second ingredient, the prosecution led evidence showing that the action of the defendant in making broadcasts threatening that people will die constitutes a terrorist act. Terrorism or a terrorist act, according to online Oxford Dictionary, is, I quote, the unlawful use of violence, intimidation, especially against citizens in the pursuit of political aim, unquote. It is also important to explain what constitutes terrorist acts. Section 1(2) of the Terrorism Prevention Amendment Act 2013 provides us, and I quote, in this section, act of terrorism means an act which is deliberately done with malice, aforethought, and which A, may seriously harm or damage a country or international organizations. B, is intended or can reasonably be regarded as having been intended to: 1. Unduly compel a government or international organization to perform or abstain from performing any act. 2. Seriously intimidate the populations. 3. Seriously destabilize or destroy the fundamental political, constitutional, economic, social structure of a country or international organizations. 4. Otherwise influence such government or international organization by intimidation or coactions. C. Involve or causes, as the case may be: 1. An attack upon a person's life which may cause serious bodily harm or death. 2. Kidnapping of a person. 3. Destructions to governments or public facilities, transport system, and infrastructural facilities, including an information system, a fixed platform located on the continental shelves, a public place, private properties, likely to endanger human lives or result in major economic loss. 4. Disposal of an aircraft, ship, or any means of public or goods transport, and diversion or the use of such means of transportation for any of the purposes in paragraph B(4) of this subsection. 5. The manufacture, possessions, acquisition, transport, supply, or use of weapons, explosion, or of nuclear, biological, chemical weapons, as well as research into development of biological and chemical weapons without lawful authority. 6. The release of dangerous substances, causing of fires, explosion or flood, the effect of which is to endanger human life. 7. Interference with or destruction of supply of water, power, or any other fundamental natural resources, the effect of which is to endanger human life. D. An act or omission in or outside Nigeria which constitutes an offense within the scope of counter-terrorism protocol and convention duly ratified by Nigeria. The Supreme Court, by my noble Lord Kekere Ekun, JSC now now the CJN, heard in Abdul Mumuni versus Federal Republic of Nigeria, and I quote, Section 15(2) of the EFCC Act provides, any person who commits or attempts to commit a terrorist act or participates in it facilitates the commission of a terrorist act, commits an offense under this act, is liable on conviction to imprisonment for life. Section 46 of the Act provides, terrorism means any act which is a violation of the criminal code or the penal code and which may endanger the life, physical integrity, freedom of, or cause serious injuries or death to any person, any number or group of persons, causes or may cause damage to public properties, natural resources, environmental or cultural heritage, is calculated or intended to intimidate, put in fear, force, coercion, or induce any government body or institution, the general public, or any section thereof, to do or abstain from doing any act or to adopt or abandon a particular standpoint, or to act according to certain principles, or to disrupt any public service, the delivery of any essential service to the public, or to create a public emergency or create general insurrections in a state. Any promotion, sponsorship of contribution to command, aim, incitement, encouragement, attempt, threats, conspiracy, organization or procurement of any person with the intent to commit any act referred to in paragraph A, 1, 2, and 3, unquote. It was further added, and I quote, the crucial aspect of offense of terrorism is the creation of intense fear and anxiety, both physical and psychological, in the mind of members of the public, which has the effect of coercing, forcing, intimidating them to do or abstain from doing any act or to adopt or abandon a particular view, policy, or position to act according to certain principles, unquote. See also the case of Rendition versus Federal Republic of Nigeria, citation supplied. In my research, I came across a handbook from the United States Institute of Peace titled Teaching Guide on International Terrorism. Definition, causes, and responses, where several definitions of terrorism were given as follows. I quote, the calculated use of violence, the threat of violence to inculcate fears, intended to coerce or to intimidate governments or society in pursuit of goals that are generally political, religious, or ideological. Terrorism constitutes the illegitimate use of force to achieve a political objective when innocent people are targeted. Terrorism is defined here as the current use or threatened use of political motivated and clandestine organized violence by a group which aim is to influence a psychological target in order to make it behave in a way which the group desires. See CJMT drag. The unlawful use of force or violence against persons or properties to intimidate or coerce governments, the civilian populations, or any segment thereof in furtherance of political or social objective is derived from Federal Bureau of Investigations. What therefore, unquote, what therefore constitutes a terrorist act from all the definition above is an act of violence, threat of violence intended to cause fear, put the recipients of such violence or threat in a state of fear. Applying the above definition to the facts of this case, the defendants in several of these broadcasts made several threatening harms to the federal government of Nigeria, the general Nigerian populace, including its own people who claim to fight for, who he claimed he fight for. In an interview with Sahara TV, contained in Exhibit PWW, the defendant was interviewed by one Rodolphe Okonkwo. He was introduced as the founder and director of Radio Biafra. When the defendant appeared on the screen, his nameplate was Nnamdi, Kanu, director Radio Biafra. While speaking on the national conference in Nigeria, which was organized at that time, the defendant mentioned the name of some of the representatives from the Southeast as the conference, and he said, if you go there and negotiate any other thing apart from Biafra, you better not come back, because our people will be waiting for you, that very person, unquote. When he was asked about the consequence for this representative, including one Ike Nwanchuku, the defendant was unequivocal when he said, things have changed, and that because the only language that people in the zoo understand is language of violence and force. After all, that very contraction was put together by Frederick Lugard by force. That is what many people don't understand. Lugard killed many people to put Nigeria together, and the killing of people to disintegrate the zoo shouldn't come to anybody as a surprise. Our promise is very simple. If they fail to give us Biafra, Somalia will look like a paradise compared to what will happen to the zoo. It is a promise. It is a pledge. Also a threat to them. They must understand it, that we have had enough of this nonsense. Unquote. It is not noteworthy that defendants in the said interview kept referring to the southeastern part of Nigeria as Biafra. The defendants made some comments, such as the governor of the southeastern state being the stooge of Hausa Fulani godfathers. He even stated that Rochas Okorocha, former governor of Imo, had institutionalized the entire state to satisfy his Hausa Fulani godfather. He said nobody had asked Governor Peter Obi about Izu River, and the person dumped in the said river. Further, during the interview, the defendants, while answering a question about whether he will embrace a peace separation or choose a violent path, stated at about 7 minutes 30 second mark of Sahara TV interview in Exhibit PWW, which is a flash drive containing all its broadcasts, said, and I quote, if they do not give us Biafra, there will be nothing living in that very zoo called Nigeria. Nothing will survive there, I can assure you, unquote. He also made reference to the Nigeria Civil War when he said, in 1967 to 1970, is not 2010 to 2015. Then we had scientists, but now we have people who can make things happen even better than what we had in the late 60s. So that should ring a warning that we are not joking. 8 minutes mark in the flash. He said, I do not believe in peaceful actualization of whatever rubbish is called. I have never seen where you will become free by peaceful means. unquote. The defendant also lent support for violent acts when he said he welcomed what a group known as Biafra Zionist group did when they unleashed violence at the Enugu State Government House. He even said he hoped more people will come out to join his group to overthrow the corrupt and inept persons in administration of the government, stating that Biafra must exist and it is their right to make sure it happens. In the broadcast of 16th May 2021, also contained in Exhibit PWW, the defendant in the beginning of the broadcast stated thus: "My name is Mazi Nnamdi Kanu. I am the leader of indigenous people of Biafra, IPOB, and director of Radio Biafra and Biafra Television. I will remain a loyal servant of the people of Biafra." He further stated around 51 minutes mark, and I quote, "If God is on our side, which I know He is, the army of Nigeria will die in Biafra land. Everybody will die. I will be the one leading it. By God's grace, everything called Nigeria will perish in Biafra land. The world must be prepared for what is to come. I want to let Katrina Lungs and the British government to know that we have chosen the path of death and people are dying every day. We have to develop the mindset of after this, which even though NATO is there, NATO is there, we say that we are ready to die, and everyone that comes to kill us will die also, because things will start happening in the next 14 days. In the next 2 weeks, the slaughter will begin to happen. You see those CNN that have refused to come to Biafra. We come by force to see what is happening. We will make sure that every Nigerian soldier on Biafra soil will die. God is my witness. I will lead this burial myself, unquote. Around 55 minutes mark to the exhibit, he said, and I quote, "I want the United Government to understand that we are ready to die than be slaves," unquote. At about 1 hour mark, he said, and I quote, "Israel was named Palestinians by the Romans because they were too stubborn. Go and ask how they did it. They bombed them, the Romans, away. Not these roadside bombs. Every road leading to Biafra will be man, landmine. Everything that is Nigeria, whether it is police, army, will blow till the kingdom come. Very neat and simple. Very neat and simple," unquote. The defendant also stated in that same broadcast, and I quote, "We are asking for our freedom, and they aren't listening. But when we start doing what we want, the whole world will start begging us, and then I will come out from wherever I am and tell them that it's too late. Throw away your phones. Remain incommunicado as we are in the state of war. It will not kill you to do away with your phones. All people should go into the bush and stop the advance of this army, or else they will kill you," unquote. These words spoken by the defendants in those broadcasts were not mere words, as they bear every traces of threats to harm people, including international representatives representing their nation in Nigeria. The said broadcasts were several in numbers, and the defendant kept repeating his rhetorics that people will die if Biafra is not created. The defendant planned to commit the terrorist act did not only manifest in his broadcast, but was shown in a meeting he had with other Igbo people in the United States. at a World Congress, Igbo Congress meeting held at the 4 Points Hotel in Los Angeles, in the United States of America, as contained in Exhibit PWW. The defendant, while speaking to the audience, stated, and I quote, "We must not miss this golden opportunity. We are bound to suffer in this time to come. You must come out to support what we are doing. We need guns and we need bullets. I know we love life so much. Without it, Hausa will overrun us. They have succeeded in imposing Okoroshan on us. They are coming. Boko Haram is coming in Igbo land," unquote. A female participant stood up to ask the defendant of his objective, as well as why need for weapons. The defendant responded, and I quote, "We now know that the best way to defend ourselves is to be armed, because Boko Haram is everywhere in Zoo, called Nigeria. So we need guns and bullets, and those of you in America will give it to us. Also, on the 22nd day of this month, something will happen called the blood moon. Most of you don't know that just before the Civil War, there was blood moon. There was blood moon in 67, and it only happens once in a while, because after this year, we will be free, no matter what happens. If we don't get Biafra, everyone will live to die. We are not joking." Unquote. His intention was quite clear. He believes only in violence as the solution to the creation of Biafra as a nation. And at the said World Igbo Congress, most of the participants were quite alarmed by the expressions as is planned, and so they kept asking if he had considered the option of peaceful dialogue, to which the defendant was adamant that only violence could lead to the achievement of his aim. These threats of violence are nothing but terrorist acts, which was duly carried out by his followers, as will be seen later in this judgment. The defendant knew what he was doing while making these violent statements. He obviously had an objective, which one, the face of it is political. That is, secession of the state of Southeast, South-South, and some middle belt states from the Federal Republic of Nigeria to form Biafra. The defendant was also bent on achieving his objective with the use of violence, and he didn't mind if his own people die in that process. As one of the crucial elements in establishing crime, the intention and the knowledge with which defendant carried out the acts can be expressed by him. If not so expressed, can be deduced from his conduct or activities or other connected circumstances. See Berede and Federal Republic of Nigeria. From the uncontroverted evidence led by the prosecution, particularly the broadcast contained in Exhibit PWW, it is clear that the defendant committed acts preparatory to and in furtherance of terrorist acts. The defendant had the opportunity to explain, but failed and deliberately refused to take that opportunity. Thus, he did not place any evidence before this court to explain the contents of the said broadcast or any reason which may be exculpatory in his favor. Having failed and deliberately refused to enter defense or give explanation, the court will rely on the uncontroverted evidence of the prosecution. This court therefore holds that the prosecution has established count one of the charge beyond reasonable doubt. Consequently, the defendant is hereby convicted in respect of count one. With respect to count two of the charge, the defendant was charged with making a broadcast received and had in Nigeria with intent to intimidate the population, issue deadly threats that anyone who flouts a sit-at-home order should write his will, as a result of which banks, schools, markets, shopping malls, fuel stations domiciled in the eastern states of Nigeria were not opened for businesses. Citizens and vehicular movements in the eastern states of Nigeria were grounded. This offense is also punishable under Section 1(2)(b) of the Terrorism Prevention Act 20 Acts. The ingredients are similar as contained in Count 1, except that the prosecution must establish that the defendant indeed issued a threat to anyone who flouted his sit-at-home order in the southeastern state of Nigeria. The evidence as led by the prosecution shows that the defendant issued a sit-at-home order wherein he threatened the residents of the southeast states from going out. He further threatened that any church, markets, schools, banks, or shops which opened will be destroyed. This was the purport of his broadcast of 30th day of May 2021, where he stated that he had an announcement to make regarding the shutdown of the entire Southeast. He stated exactly at 9 minutes 10 seconds in the broadcast contained in Exhibit PWW DOS, and I quote, "Tomorrow being the 31st day of May, there is complete lockdown, no church, no market, and nobody should be seen outside tomorrow. I do not want violence. I do not want anybody to resort to violence. I condemn it completely and totally. We do not want to spill the blood of the innocent. Therefore, I am urging restraint across board. I am urging our people to honor the memory of people who died. There will be no church, market, banks, car on the roads. There will be complete shutdown. If you want to be alive, do not come out tomorrow." What I'm saying is that do not come out tomorrow. If you value your life, there will be complete shutdown of Biafra land tomorrow. Any community that allows vehicles to pass tomorrow will be in trouble. Anybody in any car or lorry except in ambulance will be in trouble. I know some people are very foolish, trying to open their shops around 12. If you open that very shop, we will burn you inside it. Especially Enugu, Umuahia, Abakaliki people. You are very stupid. Tomorrow we will show you, unquote. This statement at first sounded peaceful and even seems as if he was only persuading people to honor the memory of some people. However, the defendant, in his typical aggressive way of speaking, began issuing threats to those who might want to obey his order, that might not want to obey his order. The people of the Southeast are Nigerians, and I take judicial notice substantially are Christians who go to church, and merchants that are into trade, and there are children who were threatened against going to church, their places of business and schools. This cause wonders if this can be said to be agitation for self-agitations. Unequivocally, I say no. The people of the southeast of Nigeria are entitled to their right to personal liberty, freedom of movement under Section 35 and Section 41 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The said section provides, and I quote, "Every person shall be entitled to his personal liberty, and no person shall be deprived of such liberty, save in the following cases and in accordance with the procedure permitted by law. A. In execution of the sentence and order of court in respect of criminal offence of which he has been found guilty. B. By reason of his failure to comply with the order of court and in order to secure the fulfillment of any obligation imposed upon him by law. C. For the purpose of bringing him before a court in execution of order of court or upon reasonable suspicion of his having committed a criminal offence. D. In the case of a person who has not attained the age of 18 years for the purpose of his education or welfare. E. In the case of persons suffering from infectious or contagious disease, persons of unsound mind, persons addicted to drugs or alcohol, vagrants for those people or purpose of those care or treatment or protection of community. F. For the purpose of preventing the unlawful entry of any person to Nigeria or of affecting the expulsion, extradition, or unlawful removal from Nigeria of any person or the taking of proceedings relating thereto. Provided that a person who is charged with an offence and who has been detained in lawful custody awaiting trial shall not continue to be kept in such detention for a period longer than the maximum period of imprisonment prescribed for him. Section 41 provides, every citizen is entitled to move freely throughout Nigeria, to reside in any part thereof, and no citizen of Nigeria shall be expelled from Nigeria or refuse entry thereby, or exit therefore. They are also entitled, unquote, they are also entitled to their right to freedom of religion as expressed under Section 38 of the Constitution of the Federal Republic of Nigeria. The right to personal liberty, movement, religion are complementary of each other. Court jealously guides these rights, and they are basic rights which enough to them as being human beings. These rights are so fundamental. Kindly see, my Lord Agagu JCA has initiated on this in Okafor versus Lagos State Government and another citation supplied. The people of the Southeast cannot be ordered to sit at home by a person, especially for someone who is not a legally recognized official of the federal government or an official of any of the states. The only person entitled to restrict movement of persons within Nigeria is the President of the Federal Republic of Nigeria under emergency power under Section 305 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The President can order for a coffee area where there is a crisis or natural disaster. The defendant is not the President of the Federal Republic of Nigeria, thus lacks any power to so declare a seat at home in any part of the country. The defendant arrogated to himself power to he lacks, and with the threat of violence, order the residents of the southeastern states to stay at home or face the consequences of their disobedience. This is an unconstitutional act which is subversive and amounts to nothing more than a terrorist act. It is also a notorious fact that the people of Southeast have been subjected to sit-at-home threats on Mondays for years now. PW4, who stated that he was stationed in the Southeast, especially in Imo State for some years, gave evidence that Monday sit-at-home is a usual occurrence wherein the town are deserted, even the farmlands. PW4 also gave evidence on the death of one Ahmad Goodluck, a former aide to the former President Goodluck Jonathan, that the said Ahmed Goodluck had been killed by airports meant in pursuant to the order of defendants. Ahmad Goodluck was trying to catch a flight out of Owerri on the 30th day of May 2021 when he ran into a checkpoint by airport and was shot dead. PW4 stated that he was one of those who got to the scene first. It must be noted that 30th of May 2021 was a Sunday, not a Monday, but notwithstanding, it leads to the death of a person trying to move around due to the directive of the defendant as shown in Exhibit PWK is a medical report from the Nigerian Police Medical Services, Owerri. The report is dated 18th July 2021 and it states, to whom it may concern, medical report, late Ahmed Gulad Ahmed, hospital number. The victim allegedly shot dead by hoodlums suspected to be IPOB/ECN members on 30th October 2021 at about 7 hours along Airport Road, Owerri. Picture of lifeless man seen, body of disease buried, information. The above medical reports, duly signed by the medical practitioner, clearly states the immediate cause of the death of Ahmed Gulak and links him to the defendant as leader of IPOB and ECN. The action of the defendant cannot be excused under any circumstances. The declaration of a sit at home without any constitutional power, especially the accompanied by the threat, is a terrorist act. The defendant did not present any evidence to rebut this case, the case of the prosecution. Consequently, he admits the evidence as presented by the prosecution. The prosecution has successfully proved count 2 beyond reasonable doubt. Consequently, the defendant is hereby convicted of count 2. With respect to count 3, the defendant is charged with professing to be a member and leader of indigenous people of Biafra IPOB, a proscribed organization in which thereby committing an offense contrary to and punishable under Section 16 of the Terrorism Prevention Act 2013. Section 16 of the Terrorism and Prevention Amendment Act provides, and I quote, any person who is a member or professes to be a member of terrorist group commits an offense and is liable on conviction to imprisonment for a time not less than 21 years. The ingredients of the offense from the above provisions are: 1. The defendant must be a person. The defendant must be a member or professes to be a member of a terrorist group. 3. The terrorist group must have been proscribed as at the time the defendant claims or professes membership of such group. As earlier established, defendant is a human being. There is no doubt about that. With respect to second ingredient, prosecution has led evidence showing that the defendant was not just a member, but he was the leader of a terrorist organization known as Indigenous People of Biafra. Indeed, in the broadcast of 16th May 2021, as contained in Exhibit PWW, the defendant, in the beginning of the clip, stated this, and I quote, "My name is Nnamdi Kanu. I am the leader of Indigenous People of Biafra and director of Radio Biafra, Biafra Television. I will remain a loyal servant of the people," unquote. He further stated around 51 minutes mark into the video, if God is on our side, which I know he is, the army of Nigeria will die in Biafra land. Everybody will die. I will be the one leading it. By God's grace, everything called Nigeria will perish in Biafra land. The world must be prepared for what is to come, unquote. In several other broadcasts, the defendant admitted being the leader of indigenous people of Biafra. There is no fact before this court showing that the defendant is not member and in fact leader of the said group. The defendant from the evidence before this court also possessed power to order the coordinator of IPOB in a broadcast dated 11th May 2021 in Exhibit PWW. The defendants, while commenting on the meeting of Southern governors held in Asaba, stated around 35 minutes to the exhibits. Why plead? And I quote, "Concerning the lockdown announced yesterday, I urge all people of Biafra and all those in Biafra land to disobey the lockdown order given by the Zoological Republic of Nigeria. The reason is because they want to use the dead of the night to move their fighters into our forest, because we have defeated their foot soldiers. Mighty Allah, we must resist this stupid lockdown, and it will not hold in Biafra. I am calling on all the coordinators, deputy coordinator of ESN, and IPOB not to sleep in their houses today, but to look for somewhere else to stay. Because now we are in the trenches. Now you will know what is freedom fighting for. It is not comfortable. It is not rosy. Do not sleep at home. Do not sleep at home. Change your phone, and even your phone itself. The defendant no doubt belongs to the group and belongs to the professing to be a member. He is a leader of the group with the influence of commanding the coordinators of the group. Not only IPOB, but even Eastern Security Network, which is the armed wing of IPOB. In the broadcast of 12th December 2020, the defendant made an announcement in inaugurating the military group known as Eastern Security Network, which is the armed wing of the indigenous people of Biafra. He stated, and I quote, "We have cowards, Pineland idiots as governors. They have given over our land to the Janjaweed to occupy in perpetuity. This very generation, this very IPOB will not tolerate it. Not now, not tomorrow, not forever. We will rather all perish and die than to allow our land to be taken over by the Janjaweed. This is a warning to all the governors who are conspiring due to one political consideration to give our land to infidel and blood-sucking demons from this time. It cannot happen, not under our watch. We are being told that some of these invaders come from Senegambia, Mali, from Niger Republic, and some from Chad, according to Governor of Katsina State, El-Rufai. Therefore, we are setting up the Eastern Security Networks to combat the excesses of these vagabonds, criminals from crossing the Jail along the same line as Amotekun, the one set up by Mighty Allah. What we are launching before the world today is Eastern Security Network, not a Biafra army, and we will let the world know when the army is to march. But for our present purposes, we are setting it up to defend our land, Biafra against Maronda from the Shahid and the Islam incursion led by terrorists, Fulani, to be precise. In the coming days, you shall see them in their uniform, performing the critical issue of providing security for our land, unquote. The defendants, who was visibly agitated, continue in the broadcast by stating, no governor in the Southeast and South-South have been able to form a security outfit. Therefore, IPOB must defend our land to the very last blood. We shall not stop, not now, not tomorrow, not forever, until our land is get rid of 20 of these Fulani terrorists. In the third video broadcast, there was a side video of the man of the Eastern Security Network dressed in black with red cap, waving black flag with insignia of Eastern Security Network. This is therefore no doubt that the prosecution has established the second ingredient beyond reasonable doubt. With respect to the third ingredient, the evidence before this court shows that IPOB is a proscribed group. I take judicial notice of under section 122 of the Evidence Act of the order made by my learned brother Nyako J in suit number FAC/ABJ/CS/A71 between Attorney General of the Federation versus Indigenous People of Biafra, today dated 20th September 2017, wherein the activities of indigenous people of Biafra were prescribed. The said order crystallized into PWJ, which is the Federal Republic of Nigeria Official Gazette number 99 in volume 104, dated 20th September 2017, titled Terrorism Prevention Order number Terrorism Prevention Order of 2017. The Gazette reads, and I quote, Notice is hereby given that by the order of Federal High Court in suit number FAC/ABJ/CS/871/2017, dated 20th September 2017, as per the schedule to this notice, the activities of indigenous people of Biafra are declared to be terrorist and illegal in any part of the country, Nigeria, especially in the southeast, south region of Nigeria, as prescribed pursuant to Section 2 of the Terrorism Prevention Act 2011 as amended. 2. Consequently, the general public is hereby warned that any person or group of persons participating in any manner whatsoever in any form of activities involving or concerning the prosecution of the collective intention or otherwise of the said group will be violating the provision of the Terrorism Prevention Act 2011 as amended and liable to prosecution. The import of the above is that beginning from the commencement date of 20th September 2017, any person claiming to be a member of IPOB commits a terrorist act. The defendant, by his broadcast of 11th May 2021, 12th December 2020, professed to be a member of proscribed group. Thus, he is in breach of Section 16(1) of the Terrorism Prevention Amendment Act 2013. Consequently, he is hereby convicted of Count 3. On Count 4 and 5, which are closely related, the defendant is charged with inciting members of the public in Nigeria to hurt and kill Nigeria security personnel and their family members, thereby committing offense under Section 1, Sub 2H of the Terrorism Prevention Amendment Act 2013. The section provides as follows: any person or body corporate who knowingly in or outside Nigeria, direct or indirectly, willingly incites, promises, or induces any other person by any means whatsoever to commit the act of terrorism, any or any of the offences referred to in the act, commits an offence under the act and is liable to conviction to maximum of death sentence. The ingredients of the offence which the prosecution must establish beyond reasonable doubt are: 1. The defendant must be person or body corporate. 2. The defendant must have directly or indirectly incite, promise, or induce other persons by any means whatsoever to commit the terrorism act. 3. The defendant must have directly or indirectly incited, promised, or induced other persons by any means whatsoever to commit the terrorist act willingly or knowingly. The defendants have been established to be a human being by the prosecution. For the second ingredient, it is important to understand what incitement means. According to the Supreme Court per Nikitobi DSC of blessed memory in CASA and the state citations supplied, hold and I quote, an encouragement here means an act of making someone to feel brave or confident enough to do something by giving active approval in support of the crime. Incitement also have the element of encouragement. By incitement, the person is provoked by a strong passion or feeling to commit an offense. The word set is a word of quite a number of synonyms. The two words set on connotes the resemblance of causing to attack or chase, like one may be say the fisherman prepare the bait to set on the fish. It also has the element of antagonism and instigation. The act of instigating means something happened by the actions or conduct of a person who is the starter. By the act of instigation, the co-accused is propelled or gingered to commit an offense, unquote. Likewise, the online Oxford Dictionary defines incitement as follows: the action of provoking unlawful behavior, urging someone to behave unlawfully, unquote. The Cambridge Dictionary also defines incitement as follows, and I quote: the act of encouraging someone to do or to feel something unpleasant or violent, unquote. Drawing from the above definitions, the incitements involve provoking or instigating people to do an unlawful act, and in their instant terrorist acts. The prosecution has led evidence showing that the defendants made broadcasts inciting public to take up arms against the security personnel in Nigeria to kill them and their family members. The broadcast of 21st day of October 2020, as contained in the PWW, the defendants said, and I quote: Radio Biafra is now in the hands of the enemy of our freedom. I don't know how much they paid for it, but I know that Britain spent over 4.8 billion a few days ago to suppress what is happening. That is what they have done. I told you a while back that Britain was now in charge of what is happening in the zoo, and you thought that I was joking. They have now come with their clamp down, but they are now going. They are not going to succeed. Radio Biafra belongs to us, but why is it not playing out our program right now, unquote. The defendant also stated, I am telling you people to go to the bush. Whenever you see a military convoy, you attack them. Whenever you see a police convoy, attack them. They are human beings and they also bleed. Any person with a police uniform or any army in any army uniform is an enemy of the people, unquote. Around 57 minutes to this video marked, the defendant stated, and I quote, they came to Tinubu. It is surprised that after British High Commissioner came to Tinubu, they opened fire on protesters in Lagos. You should know, you should not by chalk that the woman is a devil, a big devil. She too will get a comeuppance, unquote. The defendant was referring to Katrina Link, the British High Commissioner at that time. The defendant also said, from what will happen in Aba between today and tomorrow, we tell you how serious we are. Every police officer with uniform, once you come out from your house with police uniform, you are dead man walking, unquote. Callers were calling in from places like Aba, like toll gates and other parts of Lagos, Ibadan, Abuja, Jos, Abia State. Even one Jacob called from Nasarawa State. And the defendants kept giving orders for these callers and other listeners to kill every police and soldiers. The defendant even told the people how to build an improvised bomb. He asked them to go to a filling station to get fuel in a bottle and put a rag in it. Then they should set the rag ablaze and hold it at soldiers. In responding to a caller call from Abuja, in that same broadcast of 20th October 2021, the defendant, while inciting his listener to attack the relative or security personnel, stated, and I quote, that every commander they have given his name, find his children. I want to get him in trouble. When they take me to court and ask why I said such thing, I will tell them why. Find the commander. His name is Ifu Umata. Find his children. Find his children. The commander of those on the ground. Find their children. Very, very important. Find their children. Unquote. If defendants went for that, and I quote, start attacking the police, take their guns, use them against them, manufacture motor tours, cocktail, manufacture bombs to bomb them, unquote. The defendant at about 2 hours, 44 minutes, 35 second mark, while concurring with a caller who informed him of the intention of him, other IPOB members, to burn down the Ezima police station, stated, not only one, I want every police station in Aba to be destroyed, completely destroyed, and burn them down. It is an order destroying them completely. Anybody who sees them with police uniform, kill the person. Nigeria wants anarchy. We will give them anarchy, unquote. In another broadcast, the defendant, while responding to a caller, stated this: you people must devise strategy to outfit the army. There are some guns in Edo State right now, as we speak. Use those guns to kill 1 or 2 of their army officers. Take their guns and begin to kill other people as well, because they cannot sustain this protest for 3 weeks. There are guns in Edo State already. Kill the army whenever you see them. Take their guns and kill them, unquote. The incitement of the defendant for the public to kill security personnel is quite clear from his blockers. Not only incitement to kill security officers, the defendant even went as far as inciting the public to destroy all properties of federal government during the NSAS protest of 20th October 2020. The defendant, in another live video dated 20th October 2020, the defendant, while responding to calls from his foot soldier during the NSAS protest, stated, and I quote, if you leave the Janjaweed and their agents the way they operate, if you leave them, believe you believe me, you will suffer. That very hotel must be brought down. I did not say set ablaze. It must be demolished. As an example to the rest, if you have not dealt with Tinubu in Lagos, the other will not learn their lesson. Tinubu is an evil man. The hotel referred here to is Oriental Hotel in Lagos, which the defendants alleged belonged to Tinubu. While responding to a caller, the defendant urged his callers to ambush the security forces during the protest and cut them off. He said, and I quote, go to the bush. You need to cut them off from the back, ambush them, take their guns from them and kill them. They are animals and not human beings. They may be wearing uniform like police or soldier, but they are animals. Disarm them and kill them. If you allow them to escape, your life is over. And I want Lagos airport to be on flame. Breached the perimeter fence and burn down the Lagos airport. If you have double barrel or pistol, go to the airport and burn it down. Set Muritala Muhammad airport on fire. Set it ablaze right now. You are dealing with animals. Fulani Janjaweed, they do not reason, unquote. it is important to state that the said hotels and Muritala Muhammad Airport and other property in Lagos, they are not in the north, where it seems to aid with passion. Even his own fellow Igbos people have property in Lagos. With destroying the property is said to be agitation for self-determinations. The threats and destruction which follow were corroborated in Exhibit PWD2, which is a pictorial pictures of the assessment of damage done to the Nigerian police alone in the state of southern states. So many of these police stations and even police officers were killed as a result of the incitement by the defendant. Also, Exhibit PWD2A, which is a compilation of death reports and certificates of death of security officers in the report. The number of police officers who were killed was given as 128. Military officers were 37. Other security officers as 10. Number of police stations attacked were 164. INEC facilities destroyed were 9 in number. This clearly shows the extent of damage caused by the defendant through his inciting statements. Another caller called into the program informing the defendant that he was at Oshodi Papa Expressway and that they are killing them. The defendant, annoyed by this information, stated for, and I quote, "How many police or army did you kill? I don't want to hear that. They are killing you. How many did you kill?" Unquote. The caller then responded that they have burnt the Orile police stations and Ilasa police station. The defendant then told the caller not to wave the green flag of Nigeria, but a blood-stained flag with the color green, white, red. He further responded to another caller by saying, "What I want them to do is to set ablaze the United building along Marina on fire. Every federal government property in Lagos should be burnt. That is what is going to be signal to the world that people have had enough. I want every federal government building in Lagos to be on fire. Every federal government vehicle or anything belonging to federal government, burn it. Go to the Muritala Muhammad Airport, burn it. How many soldiers do they have? Manufacture your own weapons and unquote." The result of this incitement is the killing of several military officers, police officers, DSS officers. The incitement also led to the destruction of several police stations in Lagos across the southern states of Nigeria. According to PW5, he led a team of officers to investigate the destructions and killing of the security personnel that occurred during the NSAS protest of 20th October 2020, as contained in Exhibit PWD2 and Exhibit PWD2A. The results were quite alarming. The court is mindful not to attribute all the happening during the NSAS protest on the defendant. However, there is no doubt that the incitement by the defendant contributed largely to the killing of security operatives, as well as destruction of public properties. The defendant incited people to destroy property such as the Lassa police station, other police stations, and properties of the government. The evidence before this court shows that the said properties were actually destroyed, such as the Lassa police stations, the High Court of Lagos in Igoshere, as well as BRT buses belonging to Lagos State government in Oyinbo. PW2 also testified that military couples were killed by those incited by the defendants in Olu in Imo State. In addition, PW4 stated that his driver and one of his tactical officers were killed as a result of the incitement. The action of the defendants were clear, as it was aimed to cause anarchy by killing security operatives in Nigeria, which would in turn lead to breakdown of law and order. The defendant had an evil intention to create to wreak havoc on the people and government of Nigeria. Are all these actions consistent with agitation for self-determination? The answer to this is in negative. His violent outbursts, as well as his instigations of the public to attack and kill security officers in southern Nigeria without provocation, was downright barbaric and without any conscience whatsoever. The defendant did not feel any concern for the family of the officers who were slain. He turned himself to a tyrant who could take life anytime he pleased. Such persons cannot be allowed to remain in society of sane minds. His shocking instigations to kill other human beings was incomprehensible, and this court hereby condemned it. But I must say that the evidence extracted is minute compared to the avalanche of. I must say that evidence extracted in this judgment is minute and very small to the avalanche of evidence and broadcast before this court by the defendant. The defendant made extremely threatening statements, incited people to violence. The prosecution has successfully discharged its burden of proving counts 4 and 5 beyond reasonable doubt. Consequently, the defendant is hereby convicted of the said counts 4 and 5. Now, count 6. For count 6, the defendant is charged with the offense of making a broadcast received and heard in Nigeria within the jurisdiction of this court, in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, in which he directed members of the indigenous peoples of Biafra, a proscribed organization, to manufacture bombs, thereby committing an offense punishable under Section 1(2)(f) of the Terrorism Prevention Amendment Act 2013. Section 1(2)(f) of the Terrorism Prevention Act 2013 provides: A2. A person or body corporate who knowingly in or outside Nigeria, directly or indirectly, willingly, F. assists, facilitates, organizes, or directs the activities of person, organization engaged in any act of terrorism. The ingredients of the offense expected to be established are: 1. The defendant must be a person or body corporate. 2. The defendant must have assisted, facilitated, organized, or directed the activities of person or organization engaged in terrorist activities. 3. The defendant must have willingly assisted, facilitated, organized, or directed the activities of persons or organizations engaged in terrorist acts. The defendants herein have been established to be a human being. As to the second and third ingredient, the prosecution has led evidence to show that the defendant has directed members of the terrorist organization to build bombs, other explosives in order to attack security operatives. Indeed, in furtherance of its terrorist actions and following the incitement of persons to kill defendant security operative, the defendant also directed his members to build explosive devices, particularly motorford cocktail. At about 1 hour 30 minutes 36 seconds of the broadcast of 20th October 2020, as contained in Exhibit PWW, the defendant, while responding to a caller about NSAS protest, stated, and I quote, "Now, this night, I want graduates to go to work, graduates of chemical engineering, those who were born as engineers, manufacture any ordnance you can, because they are coming to kill you anyway, regardless of what you do. Go and manufacture any ordnance. I am calling on the youth in the middle belt, and I want any bridge that they can use to reinforce to be destroyed. They are going to come from the middle belt this night. We have engineers everywhere, people who are intelligent. Go back now and give us your own version of Molotow cocktail. We must destroy them before they destroy us. Every youth tonight, anybody with a police uniform, anywhere, especially in Aba, in Lagos, once you have police uniform or any army uniform, that person is your enemy. Attack them, because if you don't, they will kill you. If you are a graduate of physics or chemistry, no sleep for you tonight. Go and manufacture something to destroy the police and every army police position starting from this night. Unquote. During the said broadcast, while responding to a caller named Jacob from Nasarawa State, the defendant even told the people how to build an improvised bomb. He asked them to go to a filling station to get fuel in a bottle, put a rag in it, that then they should set the rag aflame and hurt it at a soldier. A Molotov cocktail, according to Wikipedia.com, that I accessed at 1 a.m. on 20th November 2025, is a hand-drawn incendiary weapon consisting of a fragile container filled with flammable substances, equipped with a fuse. In use, the fuse attached to the container is lit and the weapon is thrown, scattering on impact. Unquote. The online Britannica dictionary defines Molotov cocktails as a crude bomb, typically consisting of bottle filled with inflammable liquids and a wick that is ignited before throwing. Unquote. Applying the above definition, the directive of the defendant to members of the group to build improvised bombs such as Molotov cocktail is indeed a terrorist act. A Molotov cocktail is capable of causing explosions, damage like any other bombs, which aim is to cause destructions. This directive, like other directive, is a manifestation of anarchy-minded of the defendant, which is set out to express through his Biafra radio, which he claimed to be the founder and director. The defendant, through the Radio Biafra platform, carried out so many terrorist attacks, which led to the destruction of lives and property in Nigeria. The defendant is not only confirmed to local terrorists, but I hold without hesitation that he is an international terrorist, flowing from his threats to attack British High Commission and American Embassy, as well as his incitement against the British High Commissioner to Nigeria at the time, Catherine Lyons, a known woman of peace. In a broadcast of 21st October 2020, the defendant stated thus, and I quote, "Radio Biafra is now in the hand of the enemy of our freedom. I don't know how much they paid for it, but I know that Britain spent about 4.8 billion a few days ago to support what is happening. That is what they have done. I told you a while back that Britain was now in charge of what is happening in the zoo, and you thought that it was a joke. They have now come with their clampdown, but they are not going to succeed. Radio Biafra belongs to us, but why is it not playing our program right now?" Unquote. The defendant also stated, "I am telling you people to go to the bush. Wherever you see a military convoy, you attack them. Whenever you see a police convoy, attack them. They are human beings, and they also bleed. Any person with a police uniform or any army uniform is your enemy." Around 57 minutes mark into that video. The defendant directed his threat at Catherine Lyons, the British High Commissioner. He stated, and I quote, "They came to Tinubu. It is a surprise that after the British Commissioner came to Tinubu, they opened fire on protesters in Lagos. You should not be shocked. The woman is dead, is demon, a big demon. She too will go come repentance." Around 1 hour, 8 minutes, 35 second mark, the defendant also stated, and I quote, the same thing that Britain did to Biafra in what they are doing to us now, media blackout. Do you want the world to report this issue? Take over the British High Commission. That is all. Take over the consulate in Lagos. Take over the one in Abuja. Every newspaper in the world will report it in the morning. If you march on the British High Commission in morning, front pages in the world will carry it, and the world will ask why is British Commission in Abuja and Lagos under occupation by Nigerian youth. Then it is over. I'm giving you a master strategy of how you should be done. In a formation of 3 lines, there is something I want you to do. I'm announcing it on air so you understand. People should go to every weather shop around you. You know those who build bullet-proof door. I don't care how much it costs. We will pay. Everybody who is a welder who builds bulletproof, people should take those doors and put nails in front of them and stand in front of protesters so that bullets cannot go through. Push the door, get the weapons, and deal with them. When you are marching to the British High Commission tomorrow, form 3 lines. They will have the army surrounding them. They will send a cable to London that British High Commission in Lagos is under attack. They will be forced to release it. Then the whole world will know that a revolution is going on. Without that, you cannot succeed, unquote. Even recently, in this courtroom, on the 7th day of November 2025, when the matter came up before this court, the court wondered the kind of malice and hatred which the defendant had for Britain. I will produce same part of the proceedings of that day here too. Defendants, he says, there are issues at play which my Lord has not able to overcome, which even the prosecution has not even attempted to overcome. My Lord, are you asking me to go into the doors to defend myself on a non-existing law? If you can state that for the record, my Lord, I will be most grateful that you are going to try me or ask me to enter my defense where no law exists. Because if that is the position, my Lord, that means that the outcome of very trial is predetermined. A man of my station and caliber cannot be tried without any valid law. It is impossible, my Lord. I will tell you why. This was the case. This very case is bigger than this court. The case of mine started in 1957 when some brave men and women in this very country dared to ask the British to leave. The funniest thing is that all of them that pioneered that very effort, they all went to jail and were killed. Court, I'm learning this now. Then ask the British to leave. Defendants, yes, in 1957, Dr. Anthony Nao moved a motion at the House in Lagos asking the white men to go and leave us alone. From that day, trouble started. Even before then, the like of Abat Macaulay was jailed, honorable men that fought for the indignity of the black race because they want me convicted. They told me so. Absolutely, my Lord. Absolutely, 100%. They told me, They said, I will come to court to hear your case. When you take your plea, when prosecution opens, then their case, when prosecution opens their case, when you start your cross-examination, when they refuse your no case submission, I am telling you what happened a year and a half ago when you file your no case submission and is rejected. You will not go into trial. You will be there during the verdict. You will be there during conviction. The court now responded. Let me just clarify this. It is also on record. You said that the British said that 1 year and a half ago that I was not the one presiding here. I want to say this, that I know my brother too, that was ascertain it will not get into that level of having anything to do, anything, because the way you are putting it. I want to say this. I do not have any relationship with the British. I have come here to do justice. I reiterate. Can you commence your defense so that if you commence today, I can extend time for you because your time has ended today. For the U.S. Embassy, it would have been attacked if not for the closure as a result of the protest. The defendant at about 2 hours, 24 minutes, 50 seconds, mark of the video of 21st day of October 2020 broadcast in Exhibit PWW stated, American embassy is shut down. Why won't they shut down? People are protesting. This statement regarding the embassy of United States of America is quite loaded. The statement could mean several things, none which are palatable or peaceful. What exactly does the defendant mean by the American embassy is shut down? Was he trying to attack the embassy if it has not shut down as a result of protest, or incite others to do same as he did in British embassy? The inference to be drawn from the statement is that the defendant meant to do harm to the embassy of the United States by attacking or invading the embassy. Under international law, the premises of an embassy or high commission of a foreign nation is deemed inviolable. That means that even though the land belongs to a host country, it cannot invade such premises. See Article 22 of Vienna Convention on Diplomatic Relationship. Article 22 of Vienna Convention on Diplomatic Relations, 1961. It provides thus: the premises of missions shall be inviolable. The agent of the receiving state may not enter them, except with the consent of the head of the mission. 2. The receiving state is under special duty to take all appropriate steps to protect the premises of the mission against any intrusion or damage, and to prevent any disturbance of the peace of the mission or impairment of its dignity. 3. The premises of the mission, their furnishings and other properties thereon, and the means of transport of the mission shall be immune from search, requisitions, attachment, or execution, unquote. Thus, from the above, it can be said that the defendant incited for people to invade British High Commission and is threat against British High Commissioner Catherine Lyons and American Embassy is an act of international terrorism. This is the purpose of Section 3 of the Terrorism Prevention Amendment Act 2013, which provides, and I quote, any person who intentionally murder, kidnap, commits other attacks on persons or liberty of an international protected person. B. Carries out violent attack on official premises, private accommodation, or means of transport of an international protected person in a manner likely to endanger his person or liberty. C. Threatening to commit any such attack, commit an offense, and is liable on conviction to life imprisonment. The High Commissioner is an international protected person, being the representative of the British government in Nigeria as well as other staff of High Commission and Embassy of the United States of America, leaving the defendant to continue his terrorist activity who have led to an international incident involving Nigeria and other foreign nations who are good partners with Nigeria. The question to ask again is whether bombing or attacking embassies of high commissions constitutes an action consistent with agitation for self-determination. Again, the answer is no. All these acts goes to show that the criminal tendency of the defendant as well as show concrete proof of his terrorist acts. Therefore, I hold without hesitation that the prosecution as successfully established can cease against the defendant. Consequently, he is hereby convicted of count 6 of the charge. With respect to count 7 of the charge, the defendant is charged with importing into Nigeria and keeping in Ubuluzo in Ihiala, local government of Anambra State, within jurisdiction of this honorable court, a radio transmitter known as Tram 50 concealed in a container of used household items which he declared as used household items, thereby committing an offense contrary to Section 47(2)(a) of Custom and Excise Management Act, Cap C45, Laws of the Federation of Nigeria 2004. The dispute as to which law provides for the offense in count 7 has been conclusively decided by the Supreme Court in case of Federal Republic of Nigeria versus Kanu, Supra, where my Lord M.L. Gaba, JSC, while reading the lead judgment, heard, and I quote, "A calm reading of the details of the facts stated as constituting the offense mentioned or named therein would clearly and undoubtedly reveal that it deals with the offense punishable under the provision of Section 47(2)(a) of the Custom, Excise and Management Act, Cap C45, Laws of Federation of Nigeria 2004, which provides as follows: 47(2). If a person A imports or causes to be imported any goods concealed in a container holding goods of different descriptions, or he shall be sentenced to imprisonment for 5 years without the option of fine. It follows in the above circumstances that the mention of the Criminal Code Act as being Chapter C45 or Chapter C45 in Laws of Federation of Nigeria 2004 is a mere mistake in place of correct law. The Customs and Excise Management Act, under which the facts alleged to constitute an offense in count 15, is punished and punishable. The offense in count 15 is consequently recognizable and grounded in an extant existing law in Nigeria in which it was defined and described, unquote. Thus, the court will follow the decision of the Supreme Court and decide count 7 based on Section 47 of the Custom and Excise Management Act. The ingredients of the offense are: the defendant must have imported or caused to be imported goods concealed in a container. 2. The imported concealed goods must have been of a different descriptions. The evidence led by the prosecution through PW4 is that the defendant imported into Nigeria a radio transmitter known as Tram 550L concealed in container which contained used household items which he described as such. PW4 stated that indeed the Department of State Service had tracked the transmitter of Radio Biafra to a compound in Umuluzino in Ihiala, local government of Anambra State, belonging to one Benjamin Madubulu. The officer secured a search warrant, exhibit PWT, and proceeded to the compound where they recovered the container. Prior to going to the scene, PW4 testified that he watched a video of the defendant inspecting the container and the transmitter with Benjamin Modubugu. The court visited where the container was kept in the custody of the DSS, and same was admitted in evidence in the presence of the defendant as exhibit PWY, and he did not object to same. The container itself contains several household items which appear to be covered for the transmitter concealed in it. The prosecution has led evidence to show that the transmitter was smuggled into the country without same being declared to custom. That the cover of the household item was used to disguise its true content. The surrounding facts also show that the purpose for which the defendant intended to use the transmitter was to broadcast program on Radio Biafra, and this make it concealed the transmitter. This is also not. There is also no evidence that Radio Biafra is registered with the Nigeria Broadcasting Commission, as stated by PW4. Thus, it is safe to conclude that the concealment of transmitter is in furtherance of the illegal operation of Radio Biafra by the defendant. The defendant, as a consequence of resting his case on the prosecution, did not call any witness to report the evidence of the prosecution, neither did he lead any evidence to counter the evidence of the prosecution. There is no evidence before this court stating the transmitter was lawfully imported into Nigeria. The defendant had the duty to present evidence and fact to rebut the allegation made against him, but he failed and deliberately refused to do same. The court is therefore bound to believe the evidence of the prosecution. Consequently, the court hereby convicts the defendant of count 7 of the charge. I must say here that defendants have always claimed to be a freedom fighter, seeking justice for his people. Indeed, this is known in law as the right to self-determination. The right to self-determination is a political right recognized in several international instruments. Article 1 of the International Convention on Civil and Political Rights, 1966, provides, and I quote, "All people have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural developments." Unquote. The right to self-determination also entails the right of a group of people to form their political entity or their own government. Article 20 of the African Charter on Women and People's Rights also provides, and I quote, "All people shall have the right to existence. They shall have the unquestionable and inalienable right to self-determination. They shall freely determine their political status and shall pursue their economic and social development according to the policy they have freely chosen." 2. Colonized or oppressed people shall have the right to free themselves from the bond of domination by resorting to any means recognized by the international community. 3. All people shall have the right to the assistance of the state parties to the present charter in their liberation struggle against foreign domination, be it political, economic, or cultural. Unquote. Nigeria has domesticated the African Charter, which is known as the African Charter on Women and People's Rights, Ratification and Enforcement Rights, which means the provisions of the Charter are enforceable in Nigeria, provided they do not conflict with the clear provision of the Constitution of the Federal Republic of Nigeria 1999 as amended. Section 2(1) of the Constitution of the Federal Republic of Nigeria 1999 as amended makes it clear that Nigeria is an indivisible state, which means there is no room for divisions. The said section provides, and I quote, Nigeria is one indivisible, indissoluble sovereign state to be known by the name Federal Republic of Nigeria, unquote. This means that anyone agitating for a breakup of the Federation of Nigeria is going against the Constitution. However, any person agitating for self-determination can do so through the National Assembly seeking for amendments of the Constitution regarding the indivisibility of Nigeria and to reflect the recognition of the agitating state. It is after this that the procedure can be said to be completed, but not excluding a referendum. Any self-determination not done in accordance with the Constitution and laws of the country will be illegal. The defendant is not only agitating for secession of the states of the Southeast, South, and some Middle Belt states. He is doing so using terrorism as a weapon. Terrorism has become a monster in the world today, and several groups have continued to use this weapon to form separate governments. In Nigeria, groups like Boko Haram, Lakurawa, IPOP have in recent years troubled Nigeria with terrorist activities. This terror group, by their activities, has denied innocent people the enjoyment of their fundamental rights. The action of the defendant and his terrorist organization have led to the bloodshed of innocent citizens, as well as security personnel who were going about their legitimate duty. His incitement through the broadcast on Radio Biafra as well as the social media platform of the group has led to the destruction of lives and property, as well as affect the daily life of his people of Southeast. The defendant did not only threaten the government of Nigeria, but his own people. This is seen in a broadcast while addressing the death of one of the commanders of IPOP, named Ikozo. The defendant on 25th day of April 2021 made a broadcast where he stated, and I quote, Ikozo was not killed on the battlefield, but was killed in his village in the middle of the night. Not on the battlefield because of the battlefield. No army or police can defeat him. Ever since Eastern Security Network was launched, I have not seen anybody tell me that their life have not improved since it was launched. Around 21 minutes marked, the defendant stated, vengeance is a monster of appetite, forever blood-tasty, never filled. Ikozo is in heaven. He is going to be revenged, and by God, he will be revenged. All those who had hand in Ikozo's death are all dead. People walking, all of them. He also stated that Ikozo will be mourned in a special way, just like how the Oba of Benin is buried with human heads. That the said Ikozo is more than an Oba. Thank you. There is no doubt that this is contained in the broadcast. The defendant's statement was corroborated by PW4, who stated that upon the arrest of one of the IPOP commander named as Onye Army, he informed them that they were only to get 30 heads of women out of 2,000 heads of as ordered by the defendant. This court is aware that the said Onye Ami was not caught as a witness in this case, and this may affect the probative value of his evidence. However, the evidence being used, this evidence is being used as corroboration to the statement made by the defendant himself, admitted by the statements of, and is admitted as a defendant for that purpose. Corroboration refers to supporting or additional piece of evidence that supports another evidence. See Ogunbayo and the state citation supplied, where the Supreme Court held, and I quote, corroboration having been held not to be a technical terms of all, means no more than evidence tending to confirm, support, and strengthen other evidence sought to be corroborated. This evidence is to corroborate the evidence, the statements of the defendants. I must say here that the prosecution witnesses were consistent and calm in the giving of the evidence. Their calm demeanor, despite provocative questions under cross-examination, shows that them to be witness of truth. I carefully observed them, and the only conclusion to reach is that they are witness of truth. And this court readily believed them. The defendants, on the other side, from its attitude in court, was truly very cocky, arrogant. He even stated that no court can convict him. This is a direct affront on the power of the court, which this court will not take for granted, but will do justice. It is interesting to note that the defendant, who claimed to be a freedom fighter, has even caused more harm to his own people, who are predominantly Christian faith. Can this be said to be agitation for self-determination? Not at all. Agitation for self-determination cannot be to the detriment or to be detrimental to people who are supposed to be beneficiary of that said self-determination. The usual sit at home order primarily affects his own people of the Southeast. The killing of people who disobey the order are his own people. Ordering of closure of churches and schools as well as markets also affect his own people. They are unable to trade, go to school, farm, even worship on such days. The threats of violence and death have prevented these people from going about their legitimate businesses. Are these acts of the defendants consistent with the agitation for self-determination? The answer is in the negative once again. The defendant was not elected by anybody, also cannot dictate for the people of Southeast, especially through intimidation and threats of violence. He is a terrorist. He must be treated as such. In final analysis, the prosecution has successfully established the 7-count charge against the defendant beyond reasonable doubt. Consequently, he is convicted on all the 7 counts. By the time the next just 30 minutes I go to the chambers, anybody is free to come and get a certified 2 copy of the judgment.
As the court pleases,
the minute I get to the chambers, the next 30 minutes, it will be signed.
Thank you, my lord. May I invite your lordship's attention to the title of this case. It is Federal Republic of Nigeria versus Nnamdi Kanu.
I'm coming, sir.
Lord, the people, 200 million people of Federal Republic of Nigeria have brought Nnamdi Kanu before this court for acts of terrorism. And my lord, in the last few weeks or last few days, Nigeria has been a season of victims of and are victims of terrorism. But my Lord, this afternoon, now to be sentenced. My Lord, the prosecutor has a duty to invite your Lordship's attention to a few points that will guide your Lordship in the sentencing. My Lord, by the judgment just delivered, this court has again affirmed the long-standing principle that whenever Nigeria as a nation is confronted with moments, actions, and events that pose grave danger to its existence, independence, and unity, the judiciary stands firm at the stabilizing force of the country, guided by the wisdom, courage, and integrity of judges who serve within that arm of government. Terrorism, my Lord, remains one of the gravest threats to humanity. It is among the most devastating of atrocities in human history. As the leader of the proscribed indigenous people of Biafra, the convict, through his broadcasts on Radio Biafra and through the group Armed Wing, the Eastern Security Network, repeatedly attacked Nigeria and took active steps to desegregate the country. By the conviction of Nnamdi Kanu for acts of terrorism, it is clear that justice has been served to the thousands of innocent Nigerians who lost their lives as a result of the inciting broadcasts and violent activities of Eastern Security Network. Their blood of those who have died cries to heaven, and God in his mercies has given them justice. Justice has honored their cry. The families of more than 75 security officers who were murdered in the service of their fatherland will now find some comfort in this conviction. Those whose relatives were brutally killed and buried with Ikonso of the order of the convict here have not died in vain, because justice has been done. My Lord, the records before this court are replete with the losses suffered by citizens of Nigeria residing in the interstates of the Federation, citizens who, through no fault of their own, were forced to live in fear, had their businesses destroyed, and were reduced to paupers as a result of sit-at-home orders issued by the convict and violently enforced by the commanders of the ESN. Justice has today set them free from oppression and economic strangulation caused by the terrorist activities of the convict. The convict now knows that the law is greater than any individual. Therefore, justice has been done to him too, and that Nigeria has both the power and the capacity to punish anyone who, through deliberate, reckless acts of terrorism, seeks to divide the country by attempting to create the so-called Republic of Biafra by force out of the Federal Republic of Nigeria. My Lord, consequent upon the conviction, as nothing further remains but the lawful imposition of sentence. The punishment prescribed for the offenses in counts 1, 2, 4, 5, and 6 is death penalty. Pursuant to Section 1(2)(h) of the Terrorism Prevention Amendment Act 2013, my Lord, with all sense of humility, I say, sir, as a prosecutor, that this court has no discretion in that regard, and that the only sentence that your Lordship will impose for counts 1, 2, 4, 5, and 6 is death sentence. This court has the power to do so, and with respect must do so. The language of the act is clear, and the court is urged to apply it strictly. without deviation. For the offense under count 3, relating to membership of IPOB, a proscribed terrorist organization, the punishment is imprisonment for a term of not less than 20 years, in accordance with Section 16.3 of the Terrorism Prevention Amendment Act 2013. We urge your Lordship, in accordance to death sentence, to also pronounce and impose the sentence as prescribed by law, having found him guilty and convicted. For the offense under count 7, the punishment is 5 years imprisonment without the option of a fine, pursuant to Section 46 and 47 of the Custom and Excise Management Act, Cap C 45 Laws of Federation. In sentencing, this honorable court is obliged to consider the nature and gravity of the acts of terrorism committed by the convict. It was against, the acts of terrorism were against innocent Nigerians who reside in the southeastern states. It is also a terrorism act against Nigeria, whereby nobody felt safe and secure in Nigeria, having regards to the activities of IPOB and ESN. The court is also to note that the company has shown neither remorse nor penitence for the innocent Nigerians who died as a result of his directives and incitements. He has demonstrated no respect for the administration of justice. His conduct, even within the court, has been marked by arrogance and a heart far removed from humility. When he was going out, he looked at me and said, God will bless me. He won't say God will punish me. Say God will bless me. And I say amen. Because I'm a blessed man. It is not him, a convict, who can now put a curse on me. He cannot do that. So in any event, my Lord, I'm not being personal, but I want to assure you that somebody in that position ought to show some penitence, ought to show some remorse, ought to throw away arrogance and self-serving attitudes. The court is further urged to take judicial notice of the fact that the convict established Radio Biafra, a broadcasting platform operating on several digital channels, including mobile radio, Twitter, YouTube, Facebook, WhatsApp, blogs, and Instagram. It is a station with global reach. Evidence before the court, my Lord, shows that when the convict was arrested on 15 October 2015 at the Tulip Hotel in Lagos, he was found in possession of broadcasting equipment. The conduct of the defendant through online publications, live broadcasts, and social media communications constitute act of incitement, encouragement, and provocation of terrorism as defined under the Act. It is the view of the prosecution, my Lord, that without the instrumentality of the internet and social media platforms, the magnitude of destruction, division, and human losses recorded in southeastern states of Nigeria, including Lagos, would not have reached the level it attained. The digital platform becomes tools in the hand of the convict, tools of radicalism, ethnic hostility, and incitement to terror. Their amplified reach resulted in a coordinated transnational militarism or militarization of violence and destructions of public property across several states of Nigeria. The court has both the power and the duty to restrict further access to digital media through which the offenses were committed by making orders that prevent the commission of similar or related offenses, including forfeiture, confiscation, or restrictions of the means used to commit the act of terrorism. As a form of preventive control, the prosecution prays this honorable court to impose restriction on the convict's access to digital devices, online accounts, or internet facilities. In other words, my lord, anywhere he may be kept until his execution in obedience to the sentencing, if he has access to these devices, and they are cheap and easy and available everywhere in Nigeria, there will continue to be broadcasts. Maybe he will claim he was not the one. At the moment, if you open to YouTube, you see a lot of rascals talking about the proceedings of the court, trying to twist and mislead the people with what happened in court. So we're asking that your lordship should restrict him from having access to these devices. This honorable court, my lord, has the statutory power to prevent convicts from further committing offenses by making orders for the forfeiture, confiscation, and restriction by any means used for communication. We therefore pray that the court to order the forfeiture of all the broadcasting equipment, digital devices, and all electronic materials seized from the convict and currently in the custody of the Department of State Security, State Service. In particular, the radio transmitter Trans 50L, unlawfully imported into the country, should be forfeited to the federal government of Nigeria. My lord, we want to say, sir, with all respect, that it might be argued that access to information, access to digital devices may be argued within the constitutional rights, but it's not absolute. So therefore, sir, if your lordships want to order his restriction, your lordship may give him a right to acquire any, but with the permission, with the authority of National Security Advisor and the Controller General of the correctional facility that he may be put. Therefore, my lord, it's not an absolute or free right for him to begin to acquire those digital devices that may encourage him to reenact or to begin to commit the same or similar offense under his right to freedom of speech. So we are saying, my lord, that your lordship should restrict it. My lord, considering that the company has to be in a custodial facility, we are asking your lordship to direct that for the safety of the convict, for his safety, for his security, and for the protection of his life until the sentence is executed, I respectfully, sir, as prosecutor, plead with your lordship to direct that he be kept in the safest custodial center anywhere in Nigeria, because his safety is very important. Your lordship need to take judicial notice of what happened when Simon Ekpa was sentenced in Finland. There are lots of talks and talks. The convict has enemies. He has friends. But no one can say the volume or the number of his enemies who may want to eliminate him. So we are asking, my lord, that your lordship order the government of the Federal Republic of Nigeria to keep him in the safest custodial center anywhere in Nigeria. You know, and if I may say with all sincerity, I am not too sure that Kuje, where there have been jailbreaks, will be the ideal place. So I'm urging your lordship with all sense of responsibility to preserve his life until he answers his sentence. So I thank your lordship And I pray that the incidents of terrorism will cease from Nigeria, from north to east, to northwest, to north central, and as we see, may God spare Nigeria of disintegration. I want to thank you. I want to appreciate you on behalf of my colleague, Adebayo Ojo, and Suraj Saida. We're grateful to your Lordship for a well-researched, a well-reasoned, and a courageous judgment. Thank you, my Lord.
There is no doubt that the convict has waived his right to be present through his unruly attitude, the habitual unruly attitude to be in court when the judgment was read. But we must still give him opportunity to hear one or two things from him, but not personal through his person. Since his consultant is here and the offense has to do with death sentence, I will call his consultant, that was his lawyer before he converted him to consultant, if he has any allocutors to make on his behalf. Mr. Jimako, do you have any allocutors to make on his behalf?
My Lord, being an officer in this temple of justice and not being properly dressed and not being his counsel of record, I will yield this very task to Honorable Obina Agocha, who is better qualified than me, being the member of House of Representatives who represents Nnamdi Kanu.
It's okay. Honorable, let me have your full name and restrict yourself to allocutors. Allocutors is what will mitigate the sentence. Is our brother. Let us hear you. You tell us your name. We can't, because of your unruly behavior, deprive him of allocutors. Can I hear from you?
Thank you, my Lord. My name is Right Honorable Obi Agocha. I represent the good people of Iguano, Umuahia North, and Umuahia South Federal Constituency in the 10th National Assembly. My Lord, I am the direct representative of Nnamdi Kanu. That's why you see me here almost every time, showing presence and also showing solidarity with him. The matter has come to a closure for now. I'm not his lawyer. I wouldn't know whether they will seek appeal. But for now, my Lord, he's my brother. He's my friend. I went to school with him. We attended primary and secondary school together, though he was my junior. But it is my responsibility and obligation as a member of the National Assembly to represent him as well. My Lord, I plead for mercy, I plead for clemency, and I appeal for peace and for stability of not just the Southeast, but as well as Nigeria. Like the prosecutor said, Nigeria is bleeding over the last few days, and we must bring some of these issues to bear and to understand how to find common solutions to our common problem of terrorism. I also wish to appeal to the prosecution team that it is being done to Nnamdi Kanu. The other people out there also doing more worse than him.
Please,
sorry, sir.
I asked for a locutor.
Yes, sir.
Please, don't
I apologize, sir. So I want the court to take judicial notice of that this trial has gone on for almost 10 years. Kanu is almost 56 or 57 years old now. He has been absent in his family life, his children, his community, his family. So I plead for the Lord to show mercy, to temper justice with mercy. And as we move forward, it shall be great for our country. Thank you very much for the opportunity. I'm a friend of the court, having come from the other side of the government. So thank you for giving me the opportunity to address the court. Thank you, sir.
Thank you. I will consider all this, and I will rise and come back by 10 minutes to 4. You may go and come back 10 minutes to 4 for the sentencing. I will rise and come back.
Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign fatherland.
Thank you very much. We may be seated. The Governor of Lagos State, Mr. Babajide Olushola Sanwo-Olu. The Deputy Governor, Dr. Kadri Obafemi Hamzat. The representative of the British High Commissioner in Nigeria, represented by the Finance, Investment, Mobilization Lead in the British High Commission, United Kingdom Foreign, Commonwealth and Development Office, Ms. Temilola Akinrinade, members of the State Executive Council, especially the Honorable Commissioner for Finance, Mr. Abayomi Oluyomi, body of permanent secretaries, especially the Permanent Secretary, Debt Management Office, Mrs. Alake Sanusi, captains of industries, especially the CEO, Chapel Hill Denham, and financial advisor, the lead issuing house, Mr. Bolaji Balogun, as well as the managing directors, Chapel Hill Denham, Mr. Lanre Buluro, and Mrs. Kemi Awodeyin. Managing Director